We should have more. Should we go to efficiency elements? Can we draft contracts on the regular basis?
No, well, I mean, if you do, you should, like I said, we're learning from each other. We always learn. So is there anybody that can share any experience they've had, interesting experience in any contract they've drafted that has an offer, or maybe a funny, maybe an offer, counter offer, cross offer, stuff like that? And anything interesting that we can learn? Okay, let me share an experience with you. Something I'm currently doing. Sorry, is there a hand? Oh, okay. Yes. Can you go with?
Good morning, everyone. I'm Deborah Abanom. I just want to share an experience that I had drafting a particular contract. I couldn't demand, it was a school association gave my clients a portion of the land in the school for a car wash that I wanted to run in the school. And then when I asked, what's the consideration? He said, no consideration. Term of lease. So all the factors, it was even difficult to even determine, okay, they wrote a letter to him and the offer, the acceptance, consideration, nothing was clear. And I was having serious headache just drafting the contract. I couldn't assign who is the lessor, lessee. I didn't even know what to, at the end of the day, I just titled the agreement, contract agreements, and just abbreviated their names because there was no lessee, lessor, or assignee, all those things. So those kind of contracts come up and then you wonder, how do you solve this kind of issue? And I just remembered once I read a book about a veterinary medicine, and the vet doctor said, whenever he faces any disease that he has never seen in his life, he will just come up with a name because you shouldn't look at the patient or whoever, the client, and say you've never seen this kind of disease before. So that's understanding helped me draft that contract. Thank you.
Interesting. Right. So one of the things we try to use as our trainees, the illustration we use is like flying. So we're all airborne. No, sorry, we're not airborne. We're seated. So we're now fastened our seat belts with what we had. And the engine plane has been put on. Our pilot is here. And to start us on a journey is a very revered person, very knowledgeable. As a matter of fact, when she stepped in, I reminded her of my encounter with her 19 years ago in Prague, Czech Republic, at the IBA conference. And there's something that struck me at that conference. I was a young lawyer, trying to try my hands in many things. Ma, if you remember, you were the first Nigerian to sit on a panel in an IBA breakout session. And we all celebrated it at the time. I don't know if you remember that. And then I approached her and she gave me an advice, and I took that advice. She said, Kayode, if you want to make an impact in IBA or in anything you do, start at the committee level. Get involved in committee. Don't come to conference and, okay, IBA. Within the committee, let them know you. Implant yourself. Before that conference, a lot of Nigerians travel for conferences. It's like a jamboree. They go, they come out, and they don't take anything out of it. But Ma, after that event, I noted that so many other Nigerians started getting speaking slots And I'm sure she must have given that advice to so many people, and some of us took it. So Ma, I just want to thank you for that lovely advice. Today, I can't remember the year, I got involved with the PPP subcommittee of IBA, and, I started my way within that committee, and, I made a lot of friends and colleagues from all around the world just because of the advice that you gave that day, Ma. So thank you very much, Ma. That's on a personal note. Now, in the official capacity, I'm not the one introducing the Lineal Sick. I'm going to call a committee member, Ikena. Ikena, can you just come forward? So briefly, because, the day is fast spent. So she's going to help us with the takeoff. The takeoff of any program is very important. And we're very careful in selecting the person that we're bringing. She's a professor and also a senior advocate. So she's got the academic experience and, of course, the practical experience. So I'll hand over to the person that is designated to do the function, Ikena Amadi. Yes.
Good morning. Our first speaker for the day is Professor Dorothy Ufot. She's a learned senior advocate of Nigeria. She's in fact the first woman from Akwa Ibom to be elevated to the rank of senior advocate of Nigeria. She is the founding partner of Dorothy Ufot & Co., a leading Nigerian full service law firm. She has the international arbitration, litigation, and other forms of dispute resolution, including investment treaty arbitration and enforcement of foreign arbitral awards. Gentlemen, let's now welcome Professor Ufot.
Yeah. Thank you very much for inviting me. Ordinarily, I would have said no. It took me time to accept. The reason being that I recently lost my mom and she's still in the mortuary. We haven't buried her yet. So I looked at my frame of thoughts, putting my thoughts together and everything. But I'm so passionate about teaching the next generation of lawyers and arbitrators. So I said, well, the topic of discourse is what we come across every day. And it would not require me to go into too detailed technical issues, but the importance of this kind of engagement is not what is contract, what are the requirements of the valid contract. We did all of those in the university. We did all of those in the law school. And in your capacity as legal practitioners, you have done a few of them. So one of the reasons why I accepted, despite my state of mind, was that every opportunity to let you know how it works, practically, I always do not miss it. And a lot of times, lawyers mess up their clients by the way these contracts are drafted. And as an arbitrator, our job on a daily basis is the interpretation of contracts. So if you did not draft your contract very well to say precisely what you have in mind and what you intend, what will happen? Your clients will suffer from it. And most of the time, by the time the issues, if you draft a contract today, the issue, a dispute might not arise until maybe 6-10 years time. And note that the contract you are drafting will become subject. Oh, sorry. Okay. The contract you're drafting will become a subject of judicial interpretation, not just in Nigeria, all over the world. Because if you're looking at an international arbitration award, you want to either set aside, you want to either enforce. The starting point is for anybody who is going to deal with that contract is to look at what did the parties agree. Always remember, the issue is what did the parties agree. And once you have got your client to sign the contract, there's no going back. You are bound by what you have signed. And most often, your clients don't even read this contract. Many people, for instance, take an arbitration. They don't even understand the implication of the arbitration clause until a dispute arises. So, in a bit, just for I'll run very quickly with this, because as I've said, it's something we have done severally. I'll take, what is a contract? Do you guys want me to start going into that? You already know that already, isn't it? So a contract is a legally enforceable agreement between parties that create obligations each must fulfill. Essentials of contract: offer, acceptance, consideration, capacity, and legality. When there's an offer, you have to accept in exact terms that the offer has been made. If you change anything, it then becomes a counter offer. So often we see disputes arise in that aspect. You say, oh, the contract price is a lump sum contract for $10 million. And you now say, oh no, would you accept 8 million? And the other party doesn't get back to you. So what is the contract? Is it 10 million or 8 million? You must have presence of mind. And if you, I know Supreme Court has decided in one of the decisions, the citation of which I don't remember, but I know that Supreme Court has said that if you receive a letter that you are supposed to respond to, if you do not respond to it, the law takes it that you have accepted the terms and conditions of that letter. So the starting point is your presence of mind. As contract drafters, you must have a strong presence of mind that there are things that come in emails, there are things that come in letters. When we are resolving a dispute, for instance, and you say, this is the contract. Somebody like me, I will, because the two parties are saying different things and each party wants to win. Outside of that contract that you have signed, what is the communication that has gone between the parties from, say, 2005, you drafted that contract, and 2024, when the dispute is arising? So in your communication, always put your client on the communication trail, because he may not read it. These are business people. But your duty is to alert him to say, this is what they're saying. For instance, I'm drafting a contract now. It's a long-term lease. And my clients have said to me, this is what and what we want. I am stuck. Because as a dispute resolver, I know I must get it right. Now, the lessee comes and says, as an example, that
these premises, their car producers in Lagos say these premises cannot take more than 2 cars at a time or more than 2 trucks at a time. I've put that in the contract. And the lessee comes back to say, by the nature of my work, of our work, there are times that we will have more than 2 trucks on the demise premises. Now, my client has said not more than 2. In reviewing my contract, the lessee has said, no, there are instances because of the nature of our work that we will have more than 2 trucks on the premises. Then what do? I am waiting for my client to give me a further go ahead to tell me what to do. Because right now, because of that, these 2 communications, honestly, I am stuck. And my review of the contract has stopped until I hear back from my client, because there's a dispute brewing. If you are saying, and that is what I drafted, 2 trucks at any given point, and the lessee is saying, no, even the environment does not allow us to park outside the premises. And given the nature of our work, there will be more than 2 cars or trucks occasionally. I cannot move further because that is a potential area of dispute. So if we do not clarify that, the lessee puts 3 trucks there and you say, remove it. He says he will remove it. You will start the argument. So you must have presence of mind to know what to put in the contract that you are drafting. Acceptance, as I've said before, accept in the exact terms. If you alter the term, then it becomes a counter offer. Consideration, these are all the things we know. So I'm just skipping it. I'm just mentioning consideration. You must give something for something. There's no free lunch. Then even if your consideration is inadequate, once it is accepted, it's immaterial. But there must be consideration for whatever. There must be capacity. For instance, a contract with a minor, is not enforceable unless it's contract for, say, something like food and things like that. And then legality, you know that an illegal contract cannot be enforced. So for instance, if you go into an agreement with somebody to go into drug trafficking, you now have how you're going to share the money, the proceeds of the business. When a dispute, fine, if a dispute does not arise, no problem. Once a dispute arises, there are a plethora of cases that says the law will not enforce an illegal contract. So those are the main elements of a contract. Now, types of contract. This is also a potential area for dispute. I am taking this presentation from the perspective of someone that is always confronted with the interpretation of contracts in order to arrive at a sound or firm decision. Written contract, oral contract, implied contract, express contract. A written contract, of course, everybody must, go through it, sign. It is very easy to enforce. I like written contracts because if I'm sitting as an arbitrator, my confluence is that contract. Whether you understood it, you didn't understand it, once you have signed, you are bound by it. Nothing can change it. It's not like, oh, this is not what I had in mind, or this is not what I thought. You must be very, very specific. Now, nobody says that all contracts must be written. They are oral contracts. The only difference with oral contract is that it's more difficult to prove. Is somebody's word against the other person's word. But there are circumstances that may not allow you to have a written contract. Sometimes people engage in contractual relationship based on trust, like gentleman's agreement. I prefer gentleman's agreement because it enables us to know ourselves. If you and I have a handshake and say, okay, the deal is done, once you fulfill your own part of the bargain, tomorrow we have a bigger contract. We can also say again, the deal is done because we know ourselves. But where the other party does not fulfill its own obligation, and you now want to go to court or to arbitration, that is when there's an issue with written contracts. You now have to be piecing together, what did this one say? After the signing, this one wrote this, and then as a judge or an arbitrator, you now start trying to piece them together. So much as you can have an oral contract, nobody says they are not in existence or they are not acceptable. The only thing is they are just difficult to prove. Now you have implied contracts. An example of an implied contract is still a contract. And we are dealing with the enforcement of the contract, assuming you enter a taxi from Ikoyi here to Obalende, you just enter. There's an implied obligation that on arrival at your destination, you will pay the taxi driver. So there's no dispute about that. There are several implied contracts. Express contracts are the ones that we say, okay, this is what you will do, this is what I will do. All of these impact the drafting of the contract. So in drafting the contract, you have to go back to all these things we are talking about. The protection of your clients is your full responsibility. Written and oral, we've gone through that. Implied, we've gone through that. And that is that. I will now go through the things that make contracts go wrong. I will leave time for question and answer. Now, I will come to the critical contract clauses that whatever you are doing, you must ensure that in that single contract that you are holding, you've covered these, these clauses are included. For instance, scope of work. If you're looking at construction contracts, which I deal with most of the time as an arbitrator, you must clearly define the scope of the project. You want to build this building now. You're entering into a contract with a contractor. You must define what you want. For instance, this building is how many floors? We want to construct a building of 5 floors. It has to be clear. The scope of work, these are all the things that must be included in the contract. Another thing that is very essential is the payment terms. And going with the example of construction contracts, the payment is usually graduated. When you define the scope of work, you divide it into stages. And it says stage 1. Upon completion, you invite me, the employer of the contractor, to review the work and see that you have completed that stage of work. Then the employer will give you a completion certificate. After the completion certificate, you probably would have payment within, then you submit your bill. After you've received that, then you probably have, say, within 45 days or 30 days, you will be paid. Now, particularly when you look at government contracts, Sometimes it exceeds 30 days. But you know that that is what you have agreed. In most construction contracts, that is not sufficient for you to stop work or to terminate the contract, but you are looking at it. So as a contract drafter, you are all the way working hand in hand with your clients and having the presence of mind to be sure that you are following the progress of the project and that you are advising your clients at every point in time, hey, it's past 30 days since we submitted our bill pursuant to the receipt of the completion certificate. That is an area we see often in dispute resolution. And the contractor, if you do not get your payment consistently after that, you have a right, because in the contract you have included termination clauses, the trigger effect, and most often not paying the contractor is a trigger effect for termination. But in most construction cases, which I'm giving as an example, you'd also have in the contract that a dispute does not necessitate the termination of that contract. The reason being that the contractor must have borrowed money to do the project. Interest is running. You can't stop the project because there's a dispute about payment. But when it persists, then you give notice and you say, I'm going to stop. I'll give you a very good example of a dispute that I was involved in, which I blame the contract drafter only, but that's not my business. You lost, you lost. The payment clause was breached by the government, and there were lots of exchange of communication. Eventually, the contractor wasn't paid. He was frustrated. He terminated the contract. Now, there's an arbitration clause. The people who reassigned the contract to another contractor did not pay attention. So they just carried the previous contract to this disputing contractor and reproduced it verbatim and gave to a new contractor. Meanwhile, the previous contractor that has terminated the contract had imported goods from Europe. He has all his receipts. And you got him the approval of CBN to bring in these goods. Now, in reassigning that contract, you should have removed imported goods from the contract. You did not remove imported goods. So you just repeated the contract hook, line, and sinker. And the former contractor has imported goods. The new contractor is importing goods for one project. And you are disputing the fact that the former contractor who is in arbitration now should not be paid. And I was appointed by the government that is involved in this case. So even though you appoint me, but you are clearly wrong. So the worst that will happen is that you will not appoint me next time, but I will speak the truth. I'll speak the truth. So, and the contractor was agitated because of who appointed me. And I just said to myself, you don't talk to the parties, keep your calm. We must do the right thing. And so unanimously, we awarded the cost of that. But before we did that, you see, when you are sitting as an arbitrator, resolving dispute, you want to go back and sleep. You want to satisfy your conscience that you've done the right thing. So in that panel, the panel was presided over by late Justice Orojo. And I read it, I read a lot. I read everything in and out. And I saw that this former contractor, this Italian contractor, had brought in all the goods. And I know the expectation of these people who appointed me. But when you are losing, it will be very clear to you that you are losing. So you can't blame me. So I now said to Justice Orojo, I said, my Lord, I had already formed my opinion. I said, my Lord, you know these Italians, they are worse than Nigerians. All these receipts we are seeing may be fake. We have to see the goods that have been imported. We've seen the contract, we've seen the invoices. And I said, so when we are going back, we have to tell the Italians, we have to see the goods. So he said, you tell them because it's your view. So I said, look, parties, claimants, if you lose, this is what you will lose. Imported goods is the bulk of this dispute. Respondent, if you win or if the claimant wins, this is what you pay. And we want to see these goods with our eyes. Claimant, have you brought these goods? Yes. Where are they? They're in our warehouse. Where is your warehouse? On oil and gas. Okay, you know what? Respondent, you are going to give us hotel. Claimant, you buy us business class tickets. We are going to see your warehouse. Because you want to do justice according to the agreements that the lawyers have drafted for them. So cut long story short, we went to honor the arbitrator, the panel, the parties, everybody. And I told Joshua, let me take charge. Claimant, how long will it take you to arrange your containers according to the bill of ladings that we have seen? Say 2 weeks. So 2 weeks, we head to Port Harcourt. We move on to One. And I took charge. And I said, bill of lading number so and so. Yes, show me the container. Said yes. PVC pipes, where is it? There. Okay. Government, are you satisfied that the contractor had imported these PVC pipes? We did all of that. So before we left Port Harcourt, the government knew it would lose. It was very clear. The government knew it would lose. So, and is it the fault of the government? No. It's the fault of the drafter of the new contract that did not pay attention and, just copied and pasted whatever was in the other place. So that's a typical example that, and another example of drafting, still in construction. If you have a main contract and your contractor wants to sublet to a subcontract, you must marry the two. You, the head drafter, who is going to be in charge of your clients, whatever. So, for instance, if you must study the head contract and also review the subcontract. For instance, if the subcontract says, the head contract says, if a dispute arises, it's going to be resolved by arbitration, and you have not checked, your contractor, your subcontractor is entering into a contract and is saying, your contractor is entering into a subcontract and is saying, if a dispute arises, it will be mediation. Because you should marry that as a drafter, you should marry that to arbitration and link the two contracts together. If you don't do that, there will be a crisis. And even a crisis for the tribunal, how do we resolve this dispute? So a lot depends on the lawyer that is drafting the contract. I think that is the essence of this engagement, for us to know how to protect our clients. Other conditions are delivery and completion. You must state it clearly. quality standard, you must state it clearly. For instance, if you want, don't just say we want tiles as an example. You have to specify these tiles. Are they vitrified tiles or they are marbles? Because both of them have cost implications. So it behoves on you to know exactly. You have a lot of work to do. To know exactly, discuss with your client, what do you want? And then you go, so if your client says, oh, we want marble, marble is obviously more expensive than vitrified tiles. Whatever your client wants, it's all called negotiation. You must carefully negotiate. Another thing you have to, consider, a critical clause is confidentiality clause, non-disclosure. Confidentiality clauses are very critical because in going into this contract, you are exposing your trade secrets. You don't want people outside to know your trade secret. In a recent dispute, the issue, we wanted a document. I wanted, as a member of the tribunal, we wanted a document. And the respondent said, the document we want is subject of confidentiality clause, so they cannot produce it. We had to go into a serious researching the exceptions to confidentiality clauses. For instance, if an arbitral tribunal tells you to produce a document, you cannot say it's subject to confidentiality clause because we need, and given the importance, that for me, that document was the dispute. And if you're saying that that document is subject of confidentiality clause, how am I going to resolve the dispute? So in the decision, whether or not that party should disclose that document, I dissented on the basis of the fact that I cannot reach any decision without seeing that document. So that is the essence. You must know, and when you are drafting your confidentiality clause, there are exceptions to every rule. So for instance, if SEC, for instance, requires you by law or stock exchange to produce that document, you must put that in your agreement so that your counterparty does not say you have breached the confidentiality clause of that contract. Another key clause in a contract is the governing law, particularly in international contract, governing law. You must always specify the governing law. This contract, you are going into a contract with a Ghanaian company. Is it Nigerian law, English law, or Ghanaian law that will govern the contract? Once you've chosen the governing law, everything you do is hinged on that governing law. It must be clearly negotiated, clearly agreed, and firmed up. In another arbitration I did, was between a Kenyan party, was road construction, between a Kenyan party and a Tanzanian party. And the agreement was that the governing law is Tanzanian law. And my co-arbitrators, who were international arbitrators, chose to apply English law for whatever reason. And I drew attention, I was the only African on the panel. And you know, Onyibo can have a way of looking down on you or something. You do it to your peril. And we said, look, this contract is governed by Tanzanian law. So if you apply Tanzanian law, the contractor will win. If you apply English law, because there are different standards, the employer will win. So let us apply Tanzanian law as agreed by the parties. They refused. I dissented. All over the world, that award has been set aside because you went contrary to the agreement of the parties. So the governing law is very important. Another clause that you must carefully negotiate is the dispute resolution. A lot of people don't do that. Dispute resolution clause is very, very key. Is it mediation? Is it med up? Is it arbitration? Is it litigation? When you do not specify any dispute resolution clause, then it's going to litigation. You can't take, for instance, oil and gas, expert determination to the court. They don't understand it. So if you have not specifically stated that, and a dispute arises on quantities, oil and gas, certain aspects are very technical. You have to include that such a dispute will be resolved by an expert, where that is its. Another clause that is very critical is force majeure clause. Unforeseen circumstances. You see, we are used to the list of force majeure clauses, act of God, war, blah, 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 and blah, blah. Those are standards. But there is a big challenge now in the world globally as a result of COVID. So is COVID, arbitration panels and courts are having right now to decide whether COVID is force majeure, unforeseen circumstances. You promise to deliver these goods at this time. And before that time, there is a global lockdown. People are not moving. So you cannot deliver those goods at the time you said you would deliver. Now you have breached the contract. So is COVID a valid force majeure law? So now, because the pandemic has never happened to that extent, I think the last time they said is 1945. So now you can't draft a contract and you are listing force majeure clauses, the things that constitute force majeure. You may not call it COVID, but you would say pandemic. It could be any pandemic. It would include a global lockdown when people cannot move and people cannot go. So it makes it impossible for you to fulfill your obligation. In drafting that contract, you must make sure that you bring your client under the scope of what will be interpreted as force majeure. Now, another problem that the global legal world is going through is sanctions. I never knew the implication of sanctions. And a good example is, there are lots of sanctions against Russia now. And when there are sanctions like that, assets of Russian parties are frozen. Now you've entered into a contract with a Russian party based on the Russian-Ukraine war. I handled that recently and I was amazed. We just sit down here, we hear Russia, Russia, Ukraine, but people have existing contracts with Russian parties. Because your country, for instance, Nigeria has sanctions against Russia, and it says it is illegal for you to transport anything, any services to Russia. Meanwhile, you already had a contract with the Russian party. What do? If you do, you go against the laws of your country. So how do you navigate that? So globally, different things are coming up because you see, we live in a global legal world. That's the essence of IBA. And I always believe that whatever a French-American lawyer can do, we should be able to do it. So we need constantly to upgrade ourselves, train ourselves, you know, for us to know what is trending in the world. Recently, still on Russia, I was invited to be on a panel to decide a challenge of a presiding arbitrator on the comments he has made against Russia. And this was a very highly placed, retired English Supreme Court judge. So what the institution did was that they didn't choose a Russian party or English party. They chose me from Nigeria, Africa. I don't know the man. They chose a Malaysian and they chose an Indian. They say, you guys constitute the panel, resolve this challenge because it's beyond us. What do we do? And what the respondent did, the respondent is a Russian party. And he said, look, so you have to be careful. The world we live in today is too small. The respondent dug up things that the presiding arbitrator has written, his views about Russia, his views about this and that. And the respondent said, no, he will be biased against us. He cannot sit as a presiding arbitrator. He replied, and they constituted this panel. This is about 2 weeks ago. We submitted our opinion. And the unanimous agreement was that uphold the challenge. We've read his activities. He may not be biased in this dispute, but justice is not only to be done, it must be seen to be done. And when we started, I was afraid. I said, Mrs. Ufot again with our challenge, with our dissenting opinion. What if these people don't agree? When we now met virtually, they said, Dorothy, you start. And I was petrified that because, and I asked myself, if they don't agree with me, will I dissent? They say, this woman has come again with her dissenting. So when I started telling them my views, I saw the chairman nodding. I saw the Malaysian arbitrator nodding. So I was relaxed that we are, the moment I finished, they said, Dorothy, we agree with you. This one said, we are. I said, God, I thank you that, that I'm not dissenting this time again. So there are so many implications. I think I will round up there. In conclusion, the best practice in contract drafting is clear and concise language. If you mean may, specify may. If you mean shall, specify shall, bearing in mind that there are times that may be shall and shall may be may. Mutual understanding and agreement. Regular contract reviews and updates. Another essential clause that you must make sure, whether it's a local Nigerian contract between two Nigerian parties or international, a renegotiation clause. Always put a renegotiation clause. A renegotiation clause assists the parties to go back to the table to review the contract instead of terminating the contract. I give you a simple example. You drafted an agreement when VAT was 5%. Now, government makes VAT 7.5%. What are you going to pay? Your contract says 5%. The law says 7.5%. Which one? You have to abide with what the law says. So you have to go back to the drawing table, work out the calculations and come back, because that is something that has been brought about by the law, which everybody must abide by. So, sorry, I'll give you time for questions. Documented communication, as I said, please write down everything you are saying. Realistic expectations and timelines. When you know that a contract, you will take 2 years to, don't say 6 months, because that is a recipe for dispute. And commonly disputed clauses include payment disputes, ambiguous and unclear terms, quality of performance, intellectual property disputes. Dispute resolution, you can't miss that. If you don't put it, then you are going to court. Some of these international agreements don't have a place in litigation in the court. So you know about mediation, you know about arbitration. For instance, in the lease agreement I was telling you about, a lease agreement, they are saying 3 arbitrators. In my experience, the dispute that may arise may not warrant 3 arbitrators, but you have included 3 arbitrators. You have signed it, you are bound by it. So I advise them, for this kind of contract, you don't need 3 arbitrators. You need 1 arbitrator. That is because I'm drafting. But if I'm seated as an arbitrator or somebody to decide on the contract, you said 3 arbitrators, and 3 arbitrators will it be? I've talked about renegotiation, I've talked about sanctions, and I've talked about force majeure and their importance. I would like to stop here. Thank you very much. I will take some questions if you have.
The mic? I think we need to use the mic. There's a mic in the room. Share with another mic.
Okay.
Where's the mic? Okay.
It's on now. Thank you very much, Ma, for the insightful lecture. I would like to ask a question around renegotiation clauses. Would it be appropriate to have, or to be also be able to determine what triggers, what are the things that would trigger a renegotiation clause within an agreement, and how best to capture those things when drafting?
I think I have it somewhere here. Yes, you, let me see. I'm looking for the renegotiation. You see, you will, for instance, as we have discussed now, if you look at force majeure, you will identify possible issues that could arise. For instance, like I said, VAT, 5%, 7.5%. What if one party says, no, that is, you can't backdate it, is 5% that we agreed. And the other party says, no, it's against the law. So what you do, such a disagreement can lead to termination of the contract because you're arguing, going back and forth. But because you have a renegotiation clause that captures unforeseen circumstances in the contract, rather than cancel the contract, the parties go back to the negotiation table where you will sort out issues. So you can't readily identify that, if COVID, how do you know COVID will happen? But you look at different circumstances that there's a way you couch it to say that if something happens, this is what we will do. You will clearly, okay, sample renegotiation clause. Upon written request, the parties shall renegotiate, say, the dispute resolution clause in good faith, taking into account specified factors like change in circumstances of a party within 6 months. If this happens, you have to identify the triggering effect, the triggering circumstances. What will trigger is the circumstance that will ensure or advisedly allow the parties to go back to the drawing table. So you need to do a lot of research, but renegotiation clause prevents disputes, prevents termination of the contract, because, and then you go to court or you go to arbitration, because you want to continue to collaborate and to take the project to conclusion and not to terminate the contract at the slightest opportunity of difficulty. There are always going to be difficulties in contract execution. So a renegotiation clause is a cushion for the parties. Instead of tearing everything apart, you go back to the drawing table. These days, I don't do a contract, any contract, whether it's local or international, without a renegotiation. Thank you. Renegotiation.
Thank you, ma'am, for the insightful training in spite of the family grieving moments. Yes, ma'am. I want to find out, as a contract drafter, what are the things I should look out for in drafting the arbitration clause? What are the things I should look out for to determine the number of arbitrators I should include in my, how do I know what kind of
dispute?
Okay, ma'am.
The value of the dispute, but not always correct. For instance, I advised a party who wanted to go to arbitration, and the arbitration clause was arbitration 3 arbitrators. But in that contract, it was a huge contract, which was well informed to include 3 arbitrators. But the aspect of the contract that became a subject matter of dispute was small. So it was not advisable, given the value of the dispute that has arisen within the context of that contract, to have 3 arbitrators. So when they approached me to appoint me as an arbitrator, I advised the lady. I said, you're going to lose. You are going into an arbitration with a multinational oil company. You are an oil services provider. 3 arbitrators, you know what it is to pay 3 arbitrators? So go back, carry your paramount ruler to go and negotiate, to beg them. If you dare attempt arbitration, you'll be sent to the cleaners, because the multinational oil company, they have more experience, they have more funds. So when people say, oh, local content, and they are jumping to do contract with Shell, Mobil, and all of the, they don't even, the fact that Mobil has agreed to give you a contract is enough. These people are going to give White and Case, if a chance, the agreement to draft. And you are accepting that agreement without even getting a lawyer to interpret that agreement to you. It is wrong, and these parties don't like to pay. Give me $20,000, let me read that agreement for you, and they won't do it. They won't. Even if you advise them, don't take this contract to. It's not balanced. They won't. I have an agreement, a contract from. So what informs the arbitration clause is the value of the dispute. For instance, in an agreement I drafted between 2 Nigerian parties, I said, you won't believe what parties can come up with. I said dispute resolution by arbitration under the Regional Center of International Commercial Arbitration in Lagos. The counterparty said, this is a local contract. Why are we going to International Arbitration Center? We can go to Lagos Multi-Door Court House. And I had to do that. I had to change it. And I told my client, there's nothing wrong. Although disagreeing with regional center is a misconception because those institutions have small claims. But if this is what makes your counterparty comfortable, because the two parties must be comfortable to sign the agreement. Then, so I changed it to Lagos Multi-Door Courthouse. So different things inform, you just know why you want this and you know how you're going to go about it. Thank you.
Good morning. Now I want to take you back to the renegotiation clause. So basically, I want to find out if the renegotiation clause applies to all contracts, because some of us rely on precedents when we are drafting contracts, and I think I have never seen this renegotiation clause.
No, I'm echoing.
Okay, I've never seen this renegotiation clause in a maybe a maybe like a development like you want to develop a property and you're drafting a contract. I've never seen it in anything property, whatever, because most of the time these people come to you, you sit down, you revisit this contract, you talk about it orally, but I've never seen it in the contract itself. So I just want to know if it applies to all forms of contracts.
To every contract.
You can implement it in maybe in a building kind of contracts.
You know, you're talking about
developer.
negotiation. Before you enter into a contract, you negotiate. And once you have concluded an agreement, because you have a renegotiation clause in the agreement, even if it's to sell rice, any contract can have a renegotiation clause. It's again, in the renegotiation clause, you must negotiate to agree and accept it. So once the two parties agree, the circumstances that may arise for there to be a renegotiation, the important essence is that it's preventing you from going to court or arbitration. For instance, you could put that before the parties will go to arbitration, they must first try to renegotiate the contract. So you can't just jump to arbitration because arbitration is expensive. So you can put it in any contract, but it's not just any simple contract. You know, the kind of contract that you are saying, a complicated, complex contract with high volume, high value. It would be a big mistake if you do not include renegotiation clause. Thank you.
Okay, let me ask my question. Sorry, ma.
But we have other questions, only mates.
Yeah.
I think let's just take one more question from 2 months. Sorry. Okay, great. I'm sorry. So we can just take coming back. Okay.
I'll be very fast because my friend and brother is not yet your turn.
Anytime they release this very
No, my question is, as a contract drafter, how do you avoid ambiguities that arose as a result of it? How do you, as a contract drafters, how do you avoid ambiguities that arose as a result of the usage of shall and may in contracts? Because you have had issues that the contract yeah, I said as a contract drafter, how do you avoid ambiguities that may arise as a result of the usage of may and shall while drafting a contract?
Yes. As a contract drafter, you know what you want. We all know that if you say shall implies an obligation, you are bound by it. You have to do it. May is discretionary. I try to avoid discretion in life.
contract drafting. If I want 5 months, it's 5 months. I do not say the contract should be completed within 5 to 6 months. If there's a dispute, how do you interpret that? And I'll take you further. You see, when people say judges are corrupt, arbitrators are corrupt, it is the drafters who allow them to do it. If you are not definite, an arbitrator or a judge that has been compromised, because you have given him or her the leeway to decide what he wants, then you are falling into that trap. But if you are definitive, that arbitrator or judge cannot move out of the meaning. All of us know the meaning of shall. Yes. And so if you say it shall be this, we all know the implication. So there's no room to maneuver. It implies strict compliance. So that is how you must avoid ambiguity by being precise and concise and know what you want. In the example I'm giving, the contract will be concluded within 4 months from now. If you want to say that the contract the starting date is this, the completion date is that, everybody's clear on that. So in order to avoid ambiguity, you have to be very precise. After discussing with your client, you will now tell your client the advantages and disadvantages of different things. Sometimes your client comes up with an opinion. You dissuade him or her and say, no, this will lead to this in order to avoid dispute. So everything boils down to the contract drafter. Many times, lawyers have led their clients to agree because they did not, and I'm saying, figuratively. Yes. And like the example I gave you of the lawyer that just transferred everything to. So the government had to pay for goods which it did not need because we had to apply, in interpreting the contract, you have to apply what we saw there. So if you authorize the man to bring imported goods, you gave him clearance from CBN, he has brought in goods, you have to pay for it. And they were saying they are not into contract, their government, this contractor can take the goods because he will always have contracts to use the goods. No, that's not what we are here for. We are here to interpret the contract and to apply justice as agreed by the parties. Thank you.
Thank you, ma'am.
Okay, thank you, Ma, for a very insightful session. I just have some questions. Okay, one. Okay, no problem. Just one. I was going to ask, does the renegotiation clause serve the same function with a variation clause?
Yes and no. A variation clause, you already anticipate that there might be a variation. So usually if you take a construction contract as an example, I would not imagine that you will have a construction contract as an example without a variation clause. It tells you, sometimes they give you scope of work. Says this is your scope of work. And along the line, the employer says, I want to add this. You would have stated that in that contract that every variation must be in writing and signed by the parties. Do you understand? So you have anticipated, I'm not saying there won't be a variation, but for us not to start having issues, if you say we want to change this to this, it has to be in writing and signed by both parties. The reverse with renegotiation is that this is not something you contemplate or anticipate. Something has arisen.
which affects your performance of the contract. Instead of going to arbitration to, plead force majeure or something, you now say, if this and this happens, we change circumstances as an example, we will go back to the drawing table to renegotiate this contract. So those are the two instances or difference between the two. So a renegotiation clause is not something you anticipate. And in the example I gave, you are saying VAT is this, and on the basis of this, this is the VAT I will pay at 5%. Then government now says VAT is now, government policy, VAT is now 7.5. That person cannot stick to 5% because it's changed by government policy. If there is if he accepts it automatically, fine, no issue. But if you guys are going back and forth and there's a renegotiation clause, you say, hey, before we go to arbitration over this matter, let us go back to the drawing board. You bring your clients, he brings his own, and you people look at the pros and the cons and agree. And once you agree the renegotiation, then you amend the contract. Thank you.
Well, so like I said, we're using the plane as an illustration. So now we're at the cruising altitude. So you can fasten your seatbelt, unloosen your seatbelt and relax. So on that note, I want to thank you, Lionel Silk. Like I said, the way and manner she delivered, you know that she's a very seasoned contract drafter. Do you all agree? So on that note, please, can you give her a sounding round of applause? Thank you very much. This is it's a volunteering job for us, and for the speakers, they are contributing their time, their experience, their knowledge. She just said to us to review a contract at that level, she'd be asking for something like $20,000. So or more than that, of course. So from MBA perspective, silver of gold, we have none. But what we have, we will give unto you. So so on that note, the strategic negotiator is here. So we'll keep him waiting for a minute. So no, yes. So I want to invite the alternate chair of our committee, CLE committee, to present a little token to Professor Dorothy Ufot SAN on behalf of the chairman of MBA. Thank you very much, ladies and gentlemen. Wait. Okay. Wait. Okay. Thank you. Thank you. You can have a seat. Okay, right. So we're now calling the hostess to bring in the refreshments, the drinks, so relax. As you can see, it's a full hall. We didn't plan for this many people, but anyway, we're here, and we hope that we just make the best of what we have. So the next speaker is going to be talking on, I think, strategic negotiation, if am I correct? Let me just check. Strategic negotiation, is it? Oh, negotiation strategy. Okay, yes. Right. So there's something interesting I want to say about him. So many years ago, I interacted with him in the public-private partnership space. So he's one of the leading voices. In fact, I'll call him one of the fathers of public-private partnership in Nigeria. We're very passionate about it. They birth what we have as public-private partnership today. He's veered into other things. And even though he's not a professor, an academic professor, I want to confer on him a professorial chair for all the good works he's been doing. I see a lot of the work he does in teaching, in building capacity. As a matter of fact, I see it as a passion for him. You know, on LinkedIn, I follow him. He gives a lot of talks, and yes, thank you, my Lord. And I think he belongs to a university, adjunct professor, okay. So we are conferring on him a full professorship of CLE here. So I just want to bring him on, Mr. Ayuli Jemide. Before I do that, a colleague of mine would just do a brief introduction. Sheikh Shakir. No, please let her do the great honors. But yeah, please come in with a formal introduction. Please come forward, sir. Come forward. You can have a seat. Oh, you won't be sitting. Okay, all right. Okay.
Good day, ladies and gentlemen. Good day, everybody. It's my honor and pleasure to introduce Mr. Ayuli Jemide, popularly known as AJ. He's been well introduced by our chairman. He's a model Culturian. He seeks to dissent happily on issues, and he finds excitement in championing concepts that go against the, I've already said that against the good. I put it in my words. He's the founder and lead partner of Detail Commercial Solicitors, Nigeria's first commercial solicitors firm to specialize exclusively in non-court matters. We are dealing with arbitration today. He was named the best lawyer in Nigeria 2013 by the World Finance, and has led several notable transactions. We have experts in the house. Trust us when we do it. Lots of work we do behind the scenes. He's an adjunct professor at the IE Business School, Madrid, Spain. He is a regular public speaker at various fora and the author of Listen Now, Every How Negotiations Work. He enjoys karaoke, boat, water, sun and sea photography, tennis, and swimming. Thank you for honoring us.
Thank you very much. It's such a great pleasure to be here, and such a wonderful turnout. When Okeote sent me the message, I checked the date and I sent him a message back. I said, "It's a Saturday." And he said, he calls me bros. Well, don't worry, people say bros. Yes, that's okay. Because I love my Saturday mornings. I mean, it takes a lot to bring me out on a Saturday, but I'm glad to be here. And we're going to work with slides because I think that, even if you don't remember anything, when you see pictures, it strikes a chord and you take home certain pictures. I think I have 1 hour, so I have 1 hour, right? Okay. I can't afford a wristwatch, so where am I going to check the time? Is there a clock somewhere? Can you put your clock here? Put your wristwatch. Okay, because I need to be checking myself. Okay, so let's dig in straight. I've been introduced. I thought I would introduce myself properly. That's my office in Lekki, where we work out of. I'll skip some slides because of time. These are the 4 cities that are important to me. I currently live in Lagos. Okay, ma. Thank you, Leonard Silk. I grew up in Warri, so my Pidgin English is actually much better than my English. So for those of you who speak Pidgin English, we can spar after. I lived in Port Harcourt for 13 years. I went to school in Federal Government College, Enugu. I'm an adjunct professor in this school. This is what I like to do when I'm not being a serious person. And most times I'm not a serious person, trust me. I will tell you 2 little secrets. The first one is about these 3 dots. How many of you know what 3 dots means? What? Therefore, exactly. Yes. Well, at least when we were doing maths, that these 3 dots meant therefore. Right? I don't know about the Gen Z period. And you know, I wasn't a very studious person throughout school, even up to university. And I tell people that, you know, I got a first class for playing in Uniben, and a third class was my prize for playing in academics. So, but when I was in primary school, I hated maths, and, you know, I had to have a lesson teacher. And while I'm doing lesson, my mates are playing football. So I devised strategies to frustrate him so he will get angry and go. So when he puts this therefore on the board, I will say, how can 3 dots be therefore? I was in primary school. And he will say 3 dots is therefore. I said, no, therefore. Don't you think it should be 2 dots, therefore? It's a primary school child. I give you a lesson teacher, and he says, I see you don't want to learn today. I say, no, you're a teacher. You should teach me, right? And if I ask a question, you should have ready answers. Long and short is he gets angry and he says, you don't want to learn today. I'm going. I say, okay. And then off I go to play football. And then from one Federal Government College, Enugu, the geography teacher had a good habit of asking people questions at random, and if you can't answer, you stand on your table. So he asked me question the first day, I didn't know the answer. So stand on your table. You stand for like 10 minutes, then he says, sit down. He did it the second day, I didn't know the answer. I stood on my table. The third day he came to class. As soon as he wrote geography on the board and turned around, I stood on my table. So, and guess what? He never asked me a question for the whole year after that. He just let me be. So I think I've been negotiating since primary school and secondary school, just being able to do things to get out of situations. I have OCD. And don't look at me funny because most of you do. So when I come into a place and chairs are not straight, or that painting is bent, tilting like this, I would not be able to focus until I go and, yes. So all of you go and find what you have. Everybody has something. And this is the book that I wrote recently, 2021. It's available on Roving Heights. A lot of what I talk about are in this book. So people say, I'm coming here to tell you about negotiation strategies. I'm happy to disappoint you, because I'm not coming to tell you about partner, your best position, your worst position, what you do. I found out that most negotiations succeed when people learn how to build bridges. And many negotiations fail because people don't understand that they're negotiating with human beings. And the most important thing is to build a bridge than to know logic and law. Logic and law is great, but you can know all the logic and law. If you burn bridges or fail to build them, you won't get anything done, right? So in the 1 hour that I have here, I want to teach you a few things about building bridges. I want you to understand the actors. Every time there's a negotiation, there are actors. You need to understand them. You need to understand who they are. You need to learn how to listen, and you need to listen strategically. You need to know what you're listening for. You need to understand perspectives. Most times, people don't even get perspectives. You don't know the other person's perspective. And what's worse is sometimes you don't even know your own perspective. And when people ask you, so why are you saying no? You say, because no, nothing more. You need to know when there are pawns that you can use, and you need to be able to identify them and know how to use them. So these are a few things we'll talk about. Give me this, your wristwatch. Take it off. Okay, brilliant. Wow, technology. So I'm supposed to stop at 12:40, 12:43. Brilliant. Round it up to 12:45 for good measure. Okay. So let's talk about the actors. And, it's a negotiation. So most times there's somebody across the room from you, right? All the time, if you're negotiating, there's someone across the room from you, and there are people on your side, or you have your client. And your understanding of the actors is probably the most important thing and the best place to start. How many of you know what this man is doing? This guy is called a fly operator. He's the guy in the theater. We don't have theaters in Nigeria, unfortunately, but I think we do. We have him in Sun Center, but he's the guy who draws the curtain, who puts off the light, who decides, when the stage needs to be closed, when it should be open, what light, right? So he knows the script. He knows what's going to happen. He will know when one of the actors has missed their lines. He will know when something's going wrong, and he will know what to do. And, I think that to be a good negotiator, you have to be like this guy who can read the room, know what's going on, and you're able to take decisions based on situations as you find them. But most of us go into conversations like this, like that little dog, blindfolded. You don't know what you're up against. You have no clue what your barriers are. You have no clue what the other people are thinking or even who they are. One of the worst things you can do is to go and sit across a table from someone who you have no knowledge of at all. And people do it. I will Google, and it's so easy these days. You understand? Right? Some people you don't even know the name of the person who is sitting across from you. You don't know what he does. You don't know his background, whether he's a lawyer, whether he's a doctor. You have no clue. And, so you're going in like that little dog. And it's one of the worst places to be. What is the difference between information and knowledge? This is an interactive class. So, what applicability, what does that mean? Absolutely. So your ability to use data and things or information or facts that you've gotten and then using it properly, right? So information could be that gentleman there, Mr. Ibekwe, my good friend, I find that he went to Uniben, and he did go to Uniben. But because I have that information, once I walk into the room, one of the first questions I'm going to ask Mr. Ibekwe is what? Well, what university did you go to? Because I went to Uniben too. And the minute Mr. Ibekwe knows that I went to Uniben, do you know the conversation changes? Right? So what have I done? I've used information, and I've converted it in such a way that it becomes knowledge. And there are many, many things that pass you by because you're not grabbing it and asking yourself, how do I use this? Right? And some people are not even asking questions, right? So I want all of you to think about this slide. How do you cut your sandwich? And I'm going to go around and everybody must think about this. How do you cut your sandwich? Is it A, Is it B? If it's not A or B, it could be any other way. Think about it. If it's any other way, tell us how and why. And I want everybody to have an answer because I'm going to point at just anybody I like. How do you cut your sandwich? Have you thought about it? How do you cut your sandwich? Yes, you. I actually meant her, but it's good. You knew I meant you. Yes. But the minute you stood up, you let it slide. Okay, I'll take the two of you. How do you cut your sandwich? Okay, what is the any other? You cut it into 4. Why? In bits, why? It's convenient. Good. And you? Why? Aesthetically pleasing. Beautiful. What have you learned about these two ladies? Anybody who wants to talk should stand up. Put your hand up and say something. Yes. Different perspectives, yes. But what did you learn about the first person? What do you now know about her from this simple question? Yes. No, please, no shouting. Yes. If you want to talk, you put up your hand. Yes. She values convenience. She values convenience. So if you were having a small talk with her and you ask this simple question, it sticks in your head. This person values convenience, right? If she then asks you, where shall we meet? For me, I will say, what's convenient for you?
Can I read two of the responses that are on the slide?
Yes.
So someone says online says that 1A, because it's the traditional way to cut it. Then another person says it depends on who I'm sharing it with.
Depends on who I'm sharing it with. Yeah. And then what's your name? Yes. So we have someone there who is traditional, right? So you now know that this person is traditional, and in engaging the person, you know what to expect. And then you said aesthetically pleasing, right? If she comes to my office and she's sitting on my table, I know for a fact that she's going to be angry if my table is all cluttered. Am I right? And you know that some people can be angry with you not because of the logic and law that you're talking about, but they came to your table and it's all cluttered. Anything you are saying that day, they're just wondering, who is this person? And these days, it's so easy to find information. I don't need to teach you people this. Right? Information is everywhere. But the most important piece of information that you get is number 3 and number 4, the word on the street. If I'm going to have a negotiation with anybody, I typically would find who knows him. And LinkedIn will tell you people who are following someone and, you and the schools they went to. I would like to pick up the phone and say, this person went to school with you. Say, yes, tell me about them. So I know what I'm getting into. And sometimes you hear, oh, easygoing guy, easygoing lady, but just don't do this, don't cross this boundary, don't cross this boundary. Sometimes they will tell you, don't be late for that meeting, And when people ask you questions, what I call eliciting questions, and a lot of times they sound very innocent, but these are people who are skilled in gathering information that they convert to knowledge and they use it to their benefit. Sometimes people just ask you a simple question, what looks like a simple question. Why are you selling? And I don't know how people get into buying and selling either property or something without asking that question. I would always ask, why are you selling? Because it gives me insight into whether there's an advantage here for me. And some people are wise enough or foolish enough to tell you, the bank is on my case. I need to sell this to pay off a bank loan. At that time, do you know you can get you will know you can get a better price, particularly if you just put the money on the table, right? So there are all kinds of questions you should ask, and you should always ask those questions, right? And don't ask them as if you are so interested, your life depends on it. You just ask them as if it's a by the way. If you tell me, it's fine. If you don't tell me, no problem. So a lot of what we look at when we're trying to gather information, disposition. What's this person's disposition, right? And disposition can be from where they grew up, you know, it could be their religious background, it could be, you know, if they've had bad experiences in the past, it could be all kinds of things put together. It could be their profession. If they tell me someone is a lawyer, you know, I say, well, we may have a lot of arguments here, right? If they tell me someone is an accountant, then I know that he would like to see things through the numbers. You know, if they tell me someone is a military man, you know, you can kind of have, you know, basic insights. If they tell me where someone grew up, whether I grew up in Lagos or grew up in the village, you know, it gives me some insight. Whether it's London trained or went to Unilag, it gives me some insights, right? Esteem is one of the most important things that we miss out when we go into these conversations. How many of you know about the Maslow's theory of needs? Abraham Maslow. Never heard about it. Room full of lawyers, we don't read. Yeah. Maslow's hierarchy of needs, right? And he says that, you know, at the end of the day, at the top is esteem. Human beings just want to feel liked. They want to feel wanted. You know, they want to feel respected, right? Everything that we do really zeroes in on that. And a lot of times we just fail to respect people in the way that they want to be respected. And we can lose a deal just for that. Right? So if I walk into a place and someone gives me their card, and the card says, Barrister John something. Throughout the meeting, what will I call him? I must add barrister, because it tells me that that barrister is important to him. Right? And sometimes, if I'm not sure, I will ask people, please, how would you like to be addressed? So that for the 10 days, 1 month, 2 years, we're having this conversation, I want to address you the way that you want to be addressed. And if the person says, Chief John, I will never miss the chief. Even if I miss the John, I will not miss the chief. I'll keep calling him chief, right? So, and these are things that you pick up. They're so easy to pick up if you're observant. Another thing is, generation is a big issue now. It's a big issue. And, you know, a few weeks ago, I had someone, I think he's Gen Z, or, you know, but he's young, he's in his 30s or something. And he said to me, he wants to, you know, meet some guy. I said, that guy is the chairman of so-and-so bank. He said, yes, do you know him? I said, well, he's a friend of mine. What do you want? He said, oh, he's right. I said, no problem, I'll do an introduction. So I did the introduction. And then he sends me a message and says, oh, he sent the guy a WhatsApp chat and the guy responded. So he's going to send the guy a Calendly link. How many of you know what Calendly is? It's an app that I send to you with a link. Then you check all the times where I'm free, and you pick which one suits you. So I sent him a message in caps immediately. I said, call me now. So he calls me and I said, this guy is 63. He's a chairman of a bank. He's well established. You are sending him a Calendly link to fit himself into your schedule. Are you crazy? Are you crazy? Right? You've lost him if you do that. He will not respond to you, and if you push, he will block you. I said, send him a message and say, please give me the phone number of your personal assistant so I can follow up and get a convenient time to speak with you or to come to your office. He says, really, AJ, he calls me AJ, say, AJ, I didn't know that. I said, no, you didn't know. But it's a generational thing. He wasn't doing anything wrong. He was just simply doing what he knew to do for his generation, right? And many times we miss this out. Gender is another big issue, and it's getting even bigger because there are 72 genders now. You can Google it if you like, right? So it's getting even bigger. I mean, the world is no longer just welcome, let us look. The world is no longer just male and female, right? So, you can have your own thoughts about this, but as someone who is negotiating on behalf of your client, read my lips, it's not your business. It's not your business. So go there, get your job done. If somebody says, call me he, call me she, call me shim, just for the period you are there, call them they if they want to be called they. It's important, right? And then there are gender issues, right? I have a story of one. I went once with a client to close a deal with a lady. On this occasion, I really didn't do my homework, I'll be honest with you. And then this my client, nice, but very Nigerian traditional man. In the course of small talk before we started the conversation, started talking about how his wife really loves him. And he goes out with friends, comes back at 2 a.m., 3 a.m., the wife wakes up, makes pounded yam for him, and even the pounded yam is not poundo, she will boil the yam and pound it, and the woman was watching, we didn't know what was going on. When he finished, the woman said, and where are you going to at that time, coming back at that time, and you expect your wife, what kind of person are you? I don't think I can do business with you. And we thought it was a joke. The woman got up. We thought, oh, she's going to make herself a cup of tea. She'll be back. The next thing, her personal assistant came and said, Madam says I should show you to your cars. The deal closed there, right? Because there were gender sensitivities and we didn't manage it properly, right? So, things happen. And there could be more, right? Now, sometimes when you get information, there are different ways to use it. And I'll just tell you a few. One of the most important ways is common ground. And what's common ground? Is basically that you and this person share something in common. And even though this person is supposedly your adversary, the conversation changes when you find common ground. People have gotten jobs because they support Chelsea. Even if they don't really support Chelsea, they said they support Chelsea. And they know all the slangs that go with supporting Chelsea, right? I've closed a property deal because we were looking, 3 of us were inspecting at the same time. We were competing. You know how you know that 3 of you, you go to this room, you see somebody. But the lady lived in the house, and when we had finished the inspection, all 3 of us, the other 2 left and said, my agent will get in touch with you. I said, no, these people don't know what's up. So I asked the lady, I said, can I have a glass of water? She said, oh, no problem. Sit down. So I sat down. She went, she brought the water. Of course, in drinking my water, I would ask, you know, where did you grow up? This. And then the woman said, she grew up in Warri. I said, Kai. I say, Warri. Yeah. I switched to Pidgin English. Then I told her where I lived in Warri. She told me, we spend the next at least 30 minutes just reliving the good old days of growing up in Warri. And then I said, look, I'm really going to buy this your property, and I will give you X amount tomorrow, just to show that I'm serious, without even doing a due diligence. I knew I would do the due diligence before I send the money. She said to her agent, she said, please tell those other people this property is sold. I'd rather sell to my brother. Now, it may sound parochial, but it could have been Chelsea, could have been anything. Could have been anything, right? And it happens to all of us. When you find someone who you find common ground with, the conversation changes. It's a fact of life, but we don't know how to use it. Boundaries. This is another thing. So if I've learned about you, you know, and maybe I find out that you are, you know, very pious, very religious, when I come to the meeting, you know, if I was in Quilox last night, it's not your business. It's not for conversation, right? And, you know, I would never say anything, you know, things you should avoid, religion, politics, those kind of things, right? Unless the person brings it up. And if the person brings it up, if you're not sure, don't hold any strong views. Just listen. Just listen. You're going there to negotiate on behalf of your clients, not time to be talking about whether you like Peter Obi or you like Tinubu or you like Atiku. It's not your business, right? Maybe after you close the deal, you can talk about that. Right. So you need to know boundaries. And you know, the example I gave of that lady that worked out on us, you know, we didn't understand the boundaries. We didn't know that she was a strong feminist and she would take offense to that kind of conversation. Risk is another thing that you find out. Sometimes, how many of you have done things that when the thing goes belly up and you call somebody and say, see what happened, and they say, who is this person? Then you mention the person, then they say, are you crazy? Didn't you know that person? You understand? You know? I mean, there are people in Lagos that we all know never pay their debts. And some of them are the richest men in wherever. Right? So you should know that there's a likelihood, if you ask around, you will know there's a likelihood that your debts may not be paid. And you will know that your contract has to be really strong with interest, with, you know, what happens if you don't get your money. And there could be more. How many of you know this guy? So this is what Jeff Bezos says. So if you are going for a meeting with Jeff Bezos, how many people will you go with? At least you'll be careful the number of people you go with. Am I right? So those of you who like to go for meetings with lawyers, your mother, your father, your sister, your accountant, your financial advisor, don't try it with Jeff Bezos, right? And this is available information on the internet. This is Richard Branson. You know him. If something can be explained on the back of an envelope, is rubbish. Now, Richard Branson has ADH or dyslexia. Yes. So if you don't understand that, right, you're going to go for a meeting with this guy with your plenty files and long presentations. What's going to happen? You lose him. You lose him. You guys know this guy. There's a lot of information about this guy on the internet, loads and lots of information, right? And all this is there. It's not hidden, right? Like most of us, there's lots of information about most of us, right? But it just tells you how much you can find on somebody, right? So he was born 1971, tells me that he's a Gen X, right? You know, he's extremely smart, his IQ, but look at the bottom, how many lawsuits this guy has. 1,750 lawsuits as of 2021. So you know that this kind of guy, there's a high likelihood that you may end up in court. Are you better than those other people that sued him or he sued, you know? So, you know, he's a wealth guy. He named his son X. So, I mean, I'm just telling you, this guy does not do formal business plans. This is the richest man of the world. He doesn't do formal business plans. So if you go to a meeting with him and you're coming with loads and loads of documents and trying to do business plan, as far as he's concerned, look, this is a great idea. Let's just do it. We may fail, but let's get on with the program, right? So this is what he says about meetings. Meetings are what happens when people are not working. Right? I'm just giving you a sneak preview of the kind of human beings that we're dealing with. This is the richest man in the world, right? And there are many Elon Musks in Lagos. And I have news for you. Some of them are sitting in this room. We're all weird in one way or the other. And Elon Musk says this, he tweets it. He says he's pretty weird and it's time the world knew, right? So if you're going to have a conversation with a weird guy like that, you need to know how to navigate, right? You may know all your facts, you may have all your logic, you know, you may have stacked everything and all your arguments, and it may just be one small thing. So this guy grew up, his grandfather used to take him on propeller planes in those days. You know, he came from a wealthy background. And, you know, one class I facilitated, I asked someone, I said, which of you can find common ground with Elon Musk? And one guy put up his hand and he says, me. I said, how? He said, I fly a propeller plane too. So you can imagine if that guy was on my team and we were going to have a conversation with Elon Musk, who will I push in front? I'll tell him, talk about propeller planes first. True story. If you are going to have a conversation with someone who's a native French speaker and you have someone in your team who speaks fluent French, even if he or she does not know the logic and the law and the issues, take them with you. After they've spoken their fluent French about tea or coffee, then you can start the conversation. Now, quickly, how many of you know that horse riding is a very delicate thing? And just look at this horse and just think about how many things you need to do or put on the horse to saddle this horse in such a way that the horse is comfortable and the horse will give you a comfortable ride. If any of those things is misaligned and the horse feels uncomfortable, different things can happen. And many times, the reason why some deals don't close is because we don't understand the horses we're dealing with and how to saddle them. And some other person understands that horse better than you, and they get that deal done, right? So what are the things that can happen? Hesitance. Skambok. And you see these things happen. I'm just being figurative, but you see these things happen in negotiation. When people are hesitant, they're balking. They then get agitated. Happens. Aggressive. It happens. That's when people start banging tables and saying, please leave my office. And finally, we topple the whole thing. And when we topple it, we come back to the office and say, that guy never wanted to do the deal. Then we hear tomorrow he's done a deal with somebody else. Same price, probably even less. To top it off, this is Mark Cuban. He says, don't call me, just email me. And if this guy does business with a typical Nigerian, we won't cross, because typical Nigerians love to call. And they love to call you without sending a message and say, is this a right time? You just get a call. And when you don't pick, what happens? They keep calling. They keep calling, like as if you didn't hear, or, you know, they keep calling. They can call you 10 times, and you could be in a meeting, right? And tell me, if that person wanted something from you, they've already rubbed you the wrong way. So you don't keep calling people. You shouldn't call people that you don't know. And even people that you know, send a message and say, I would like to have a conversation with you. Tell me a right time. Many times they'll call you immediately. Let's do a small exercise. It's 12:21, right? I have 20 minutes more. 25. 25. We rounded it up. Make it 25. I'm negotiating here. What irritates you most about people? And I know where I'm going to. And some people should share. Just share. And don't give me that look like you don't get irritated. Just stop it. Stop that look. Everybody here gets irritated. Something irritates you. What is it? Nobody wants to say anything. Oh, you, yes, tell me. Or you.
Okay, when someone steps on me and they don't apologize.
Just stepping on you.
Yes, it gets me mad.
That really happens unless you're in the bus stop. Please give a good example. Yes.
When people talk too much, unnecessary.
Talkatives.
Yeah.
Yes. I'm like that. Talkatives. Talkatives. If you're a big talker, I will convert myself to a big listener. And I won't say a word. And sometimes when you don't try to say something, they interrupt you and they continue. Just let them be.
Okay. When people are unnecessarily rude.
People are unnecessarily rude.
Yeah.
Polite. Yes.
People.
Okay. Okay, good. Good. So if we go around, okay, give me one.
Okay, people who don't use deodorant. Deodorant. Yes.
The truth is, sometimes we irritate people out of a transaction. Let's be real. And if our clients knew how irritating some of us are, they won't send us to negotiate on their behalf. True story. But you know what's worse? We don't even realize. We focus more on the other person. Have you ever asked yourself, what is it that I do that irritates other people? It's a good question to ask. And you should ask your friends. Because sometimes you fail to build bridges because you're doing something that irritates people, like being lengthy. I want you to monopolize the conversation. Many people don't like it, right? And as you work on that, it increases what I call LQ. And what's LQ? It's something I came up with. People have EQ, emotional quotient, IQ, intelligence quotient. These days, there's LQ, likability quotient. The chances that someone will like you, you can work on it deliberately. And that's why some people go into a room, they have a conversation, and it takes 5 minutes. They come out smiling. Another person goes into the room, same conversation, you know, they bungle it. Okay, let's talk about listening. And this is where most of us need to listen. And this for me, if an average Nigerian won't learn anything, we need to learn how to listen. When you talk to a lot of foreigners, particularly Americans and Europeans, from the questions they ask you after you've spoken for a bit, you know that they have been listening to you. And they let you finish. So, in some other class where I had time, there was a particular song that I would play. It's a Tupac song, Tupac Shakur. And, you know, when we play it, I ask people to listen and they hear all these things in that song. That they've been listening to that song for many years, but they were not hearing all these things, right? And then it leads us to the question whether there's a difference between listening and hearing. Are you recording this? Okay. Whether there's a, because I was about to drop this mic and speak. Well, no, it's okay. Whether there's a difference between listening and hearing, the mic is echoing. So my OCD is getting to me now. Is there a difference between listening and hearing? What's the difference? Attention. Someone says attention. What else? Context. What do you mean by context? Just tell me, hearing is this, listening is this. When you just give me one word, attention, context, I'm lost. I'm not that intelligent, so you have to break it down for me. Yes. Thank you. Thank you. Processing what someone is saying. If you can't process what someone is saying, you're not listening. You're just hearing. And it says, taking a second to consider what they are saying, to consider. And many of us are not considering things. We're just hearing. And this guy says the single biggest problem in communication is the illusion that it has taken place. And that illusion happens every day in the business world. You go for a meeting, you come back. Amongst your colleagues, 3 of you, you are reporting 3 different things that you heard. The counterparty sends an email, you say, no, this is not what we agreed. Then there's an argument among the 3 of you because there are 4 different things that were heard. People are listening to reply. And how do you know people are listening to reply? When they reply you, it's clear that they didn't hear what you said. And many times you say, but that's just what I said. So, no, that's not what you said. Because they were not listening. And we do that a lot. It's a very Nigerian thing. And this philosopher says we have 2 ears and, am I okay? Okay. You were looking at me like you were trying to pass a signal. Okay. So my stop time is 12:45. Okay, good. Not 50. Okay, good. He says you have 2 ears and 1 mouth. Why? So you should listen twice as much as you speak. People should learn to sit down in meetings and listen. Those who listen, they're the best negotiators because many times they already know what you are thinking and you don't know jack of what's in their head. Nothing strengthens authority as much as silence. And I'll tell you, this works. At one event, I was supposed to be chairman of an event, Nigerian wedding. Nobody makes speeches in Nigerian wedding. Nobody listens to you. You know that. Even the bride and bridegroom speech, nobody listening to them. Everybody's milling around. So I was, may I have your attention, please? May I have your attention, please? Oh, nobody listening to me. So I just kept quiet. I just kept quiet and started making eye contact, table by table, table by table. And with each table that I made eye contact with one person and stared at them, they said to the other people, keep quiet, keep quiet, keep quiet. And the whole was just very quiet. I could have been shouting there for 1 hour. Nobody will listen to me. And sometimes when someone is talking, and you just keep quiet, you get their attention. This guy tells you that successful people are good listeners in a nutshell. Okay, so what should we listen for? The most important thing that you're listening for is what's not being said. The best negotiators are those who can hear what is not being said. Because most times, people are not telling you everything. And of course, they're not telling you everything because they want to get the best deal. How do you listen for what's not being said? There are some triggers. And let's start with voluntary information. What people tell you. And many times, even what they tell you, we don't grasp it, right? But sometimes what people tell you is important. So if you're really listening, that's important. Answered questions. Many of us ask questions and we don't even listen for the answer, how the answer comes, or whether it comes. Unanswered questions. If you ask someone a question and they fail to answer, or they pivot, or they slide, or they change the topic, it's a trigger for you that there's something there they're not telling. The obvious not said. We're very intelligent people. And many times someone tells you a story or tells you a logical argument. And inside the logical argument, they miss one pillar that they themselves should have put in. And you can deduce that they deliberately didn't talk about that part. And it was so obvious, there's no reason why they shouldn't have. Then you know there's something there. Audible whispers. And people ask me, how can whispers be audible? The average Nigerian whisper is audible. I love my country, I know my people. And I've been for negotiations where people are whispering across the table. And all you need to do is pretend that you're not looking at them, but actually getting your ears to focus. And many times when you tell your ear, listen, it picks up things that ordinarily you'll be surprised, right? So I've been in a negotiation where someone said to me, was whispering to the other person, we will start at 100, but where we want to end is say 80. And me, I could have even accepted 50. So when they say, what's your price? I say 100. Or, you know, it was a 5-minute conversation. Inaudible whispers. So many times you can't hear what people are saying, but you can deduce. And how do you deduce? I look at faces. I look at faces. If the person listening puts on a great face, I say, this is very important. I watch. If they look at their notes, I say something about what we've just said. If the person makes a mistake of looking at me, I say, this is about me. There are ways, right? If they smile, I say, okay, maybe this is a joke, right? So you have to pay attention in every situation. And people gasping means a lot. And a lot of times, you know when people are lying because their colleagues sitting next to them gasp. I don't know if you have seen it. If you're watching, and every time you need to watch everybody in the room, keep your eyes on everybody. Or yawn. Someone has been with you for 1 hour. How come is when you ask that particular question, they decide they want to yawn? They're suddenly tired. Do you understand? Or side glances. If I ask you a question and you look at her, it tells me she's probably the decision maker. And you need validation. But I need to be watching. Eye contact. People who can look you straight in the eyes. Or when you ask a question, the gaze averts. That's it. Body movement. Suddenly, I'd have to now start moving this tray all over the place when I'm saying something. What has the tray done to me? You always have to watch who the decision maker is when you go for conversations. And sometimes the decision maker is even the person who is not talking. But watch who they look to for validation. And always watch everybody. The person who is not talking can be saying something to you just from their posture. And different tunes. Sometimes people are disagreeing with each other across the table from you. You have to be able to identify when they're disagreeing and identify who is on your side or who is agreeing with you. And you have to then know who you need to convince. And when you're trying to convince people, you look at them. So if I know that this thing is about budget, then this is the CFO. When I start talking about why my product or why what I'm bringing shouldn't be compared with that or that, I'm looking at the CFO, right? And there's something about eye contact. It speaks more than what you say. And there could be more. Okay. So many of us don't know this, but you know, the face shows a lot of emotions. And we should always look out for these things, right? Always look at people. Look out. Look out when you say something. Look out for how people are reacting, right? And what's most important is look out for yourself too. You need to learn to keep a poker face. As difficult as it is, I find it difficult to keep a poker face. So what do? When I realize, look, Ayuli, your poker face is not working, I smile. Because then smiling is difficult to interpret. To mean many things. And when I know I'm about to frown, I say, if I frown now, they will know that I'm not happy. I really smile. I smile. You train yourself to do these things. You smile. Because you don't want to give away the fact that what this person said is rubbing you the wrong way. It's a great poker face, isn't it? Yes. Now, the guy who came up with that, the micro expressions that I showed you, he did the study across many countries. And he says that that face is the same, irrespective of your nationality. A smile is a smile, whether you're Japanese or Chinese or Nigerian, and all that, right? So, I don't have time, but let me just run through this. I may have to skip this. I may have to skip some slides. But I think this is important. A lot of times, negotiation is more psychology than logic and law. Logic and law is great. It helps, right? And this guy wrote a book. That's the book. I strongly recommend it, The Chimp Paradox. And what is he saying? He says that the average human being, every human being has in their minds the human side of your brain, which is rational. And you also have one part of your brain which is emotional. And that part actually behaves like a chimpanzee. So he calls it the chimp, right? And these are studies that people have spent time doing. And he says there's a part of your brain which is the computer. It stores memory, and it feeds the chimp and feeds your human side. And the human side and the chimp interpret differently, right? So the human side is logical, the chimp thinks emotionally. And so sometimes when you see yourself behaving in a particular way, you should know that it's your chimp that has taken over. And sometimes when you see somebody behaving in a particular way, you should know that they've left their rational side and the chimp has taken over, right? And the chimp is usually irrational, anxious, insecure, and all these things. But he says, you need to manage their chimp and you need to manage your chimp. How do you manage their chimp? Sometimes you just keep quiet. How many of you remember what happened, Jega and Erubebe, during the 2015 elections? You watch that clip. Jega probably read this book. He said sometimes you just need to allow people shout and talk and shout, and you say nothing until they've exercised the chimp and the chimp is exhausted. They themselves will come and say, okay, I'm sorry, let's continue from where we stopped. But if you engage, then it can topple, right? Sorry. I need to rush now. I think I have 3 minutes more, so I need to just get you out of here. I won't finish, so anywhere I stop is where I stop. Pawns. Pawns are things that you typically use to gain advantage. And one of your biggest pawns is time. It's time. So when people ask you, how soon do you want to close this? They're finding out whether you have time. And if they have time on their hands and you don't, and you've told them, then they can know how to use it. I once did a property deal in somewhere in VI, and I was negotiating on behalf of my client, who unknowingly encroached on someone else's land. He bought a piece of land that was already fenced. When the neighbor wanted to start building, the architect told them, your land is short. Then they started, and it happened that there was a subdivision at some point many, many years ago. It wasn't at fault. So he says, look, he needs to negotiate with the owners of the land. So I sat down with the guys, they were Italians. And so I said to them, I said, what are you building there? Just, fishing. Oh, they're doing a high rise. They already have an offtake agreement from one oil company, and time is running out on them because they have drop date to deliver. So I said, okay, good. We've had our first meeting. We've met each other. That's a great place. So we can fix a meeting now to start the negotiation. So why can't we start the negotiation now? I said, no. I didn't plan to be with you for more than 20 minutes. I have somewhere else I'm going to. So, okay, when can we see? How about next week? I said, next week. I'm not sure. Because I knew they were in a hurry, so I needed to slow it down. And I slowed it down next week. Sometimes I will come, I will discuss one point, and then, by the time they pushed me to a final meeting, I said, no, we must close this today. I said, fine, you are ready. And by that time, the son who had taken over the company had come with the father. The father had started coming for the meetings. So I knew this thing was very important to them. They didn't know I picked up that piece of information from just gisting with them. And when I said we're going to do it like this, the son will say, no, we can't. The father will say, stop it. Done. Next. Time was the pawn. And there are many pawns. There's venue, there are substitutes, there are facts and principles. I can't go through all of them. It's 12:45. I would like to respect the time of the organizers. So I will stop here. Thank you very much. Sorry, before we go to questions, there's a car that's blocking. Is there a Lamborghini? No, unfortunately not. Questions, let's take the questions so that the next, yes. Questions, yes.
Thank you very much, sir. Please, can we get the slides? Please. Just us in this room.
Truth, you won't understand them.
Just so we can go back if we need to.
You won't understand these slides. I trust me.
We will.
Okay, I'll talk to you after.
All right, thank you, sir.
Yes. Any other question?
Yes, sir. Okay, sir. So I want to just say something.
Yes.
You have said a lot of things about how to basically understand your audience. So I want to ask you that because I think most of the time when we get into these negotiations, we don't actually know these people.
Yeah.
So what's the first thing to do? Because you don't know them and you need to start applying everything that you've said. So what's the first thing to actually do?
What's your name?
Fola, sir.
What?
Fola.
Fola. That's where to start. What's the name of this person? Many times we go for meetings, we don't know. It's when we get to the meeting that we know the name of the person. And if there's a lawyer working for them, I say, which firm? What's the name of the person? I want to know whether it's someone that I know, whether it's someone that will be friendly, whether it's someone that will be hostile. You understand? You are in the market. Let's be real. When it comes some names, you will expect hostility. Right? Yeah. And if I know the names, I know who to send. There are some meetings that say, oh, I won't go for this meeting for strategic reasons. Right? So that's where you start from. Identify who the person is. Then you can start finding knowledge around the person, their interests, their whatever. Yeah.
Next question. Sorry, the car is a Toyota. I don't know what make of Toyota, but the plate number is FST 86JA, Lagos.
Color?
White. I believe it's white. Is your thank you.
Is it when we said white that you don't realize it was your car? How many of you know your car numbers? I don't.
Yes. Thank you very much for this insightful presentation. My question is on venue, although it wasn't talked about.
Yes.
Venue. So presently, I work for Ikoyi Club.
Yes.
The lawyer. I have this negotiation that's about to come about, and then the other party has said we should come to their office. I should come to their office. And my question is, how best, or what's the best place for a venue, and how do you determine the venue? Would you go to their side, or you let them come to?
It's situational. It's situational, but to tell you, anytime I'm doing a cross-border, sorry, it's my OCD, one house. Anytime I'm doing a cross-border negotiation where my client is Nigerian, I try to push my client to say, let them come to Lagos. Because most times when I go with clients to London or one city, we always get the shorter end of the stick, or we don't get as long an end as we can get. Why? They play tricks. They slow down the conversation. They know you're paying hotel bills. You understand? They agree something today, disagree tomorrow. They bring up new things, right? People go as far as putting you in a room with the heater not working well during winter, you know, and then when it's time for lunch, you know, you are expecting a warm meal. You're African. They bring you a cold salad inside our winter. You know, so it depends, right? If it's someone that I need to show esteem to, and the person says, I will come to your office, I'll say, no, sir. I come to my office. Oga, I will come to you. Right? You already buying yourself brownies by showing, look, I respect you. Right? Yeah, but if the person insists, no, it's okay, you know, if you insist. Right? So it depends on what you want to achieve, who you are dealing with, and the situation. Right? So again, there are traditions in our profession, right? Senior lawyers expect that younger lawyers will come to their office, right? So if you start pushing a senior lawyer to come to your office, you're already touching a sore point. Wherever the office is, if he says come to his office, you want to get your deal done, go there, right? So you have to be situational about it. There's no hard and fast rule.
Thank you very much. Oh, do you have, please make it very
Good afternoon,
brief.
sir.
Yeah.
Thank you for the.
Please come forward so we can.
Thank you for the knowledge you've shared with us. I want to know how you would escape eliciting questions, because I come across that offhanded questions they ask innocently. How do you escape them, manage them?
Answer a question with a question. And answer a question with a question and put some humor. So you ask me, why are you selling? Why do you want to know? Do you understand? Why do you want to know? Yours is to buy, isn't it? You know, or you don't want to buy. You know, so don't. If you escape it by sliding or pivoting or avoiding it, then you will tell. Do you understand? So don't shy away from it. Don't answer it, but say something. Have a comeback. Yes. Yeah. You say what? Yeah, have a comeback. I say you can say to people politely that if it's someone that's your peer or your age mate, say, please mind your business, Joe. Why am I selling? You understand? You know, just put your money on the table. Does that matter to you? So you must answer. But if you keep quiet, for me, it tells me there's something you're hiding.
Well. So this is the part that they've served you your meal, you've enjoyed your appetizer, desserts, main course, and the drinks. So well done. His main course, yes, well done. As you see, negotiation is not a skill. You know, it's deliberate. And I've learned a lot from the insights that he's provided. In fact, there's something that happened once. I traveled with clients. I noticed that they gave us very heavy, sugary breakfasts. And the clients were in their 60s and early 70s. And it was 10 hours behind Nigeria. The main course of the negotiation starts off around 4 p.m. their time, between 2 and 4. Between 2 and 4, there is maybe like 10 to 12 midnight. My clients are already falling asleep in their 60s. And then I just told them, I said, please don't let us sign anything yet. Let's go back to Nigeria and then review. When we got back and they saw what was agreed, they didn't believe it. So thank you very much for the insights you provided. I'll call one of my colleagues, Mrs. Banjo, Yemi Banjo. Again, as we've said before, I mean, you were here where we said, we can't pay for your expertise and time, but we have a very small gift for you on behalf of, on behalf of the chairman. Please, let's keep it coming, yes. Okay. Oh, sorry. Oh, sorry. Oh, I'm so sorry.
Okay. Thank you.
So we did all the way. Please scrap that.
Thank you, everybody.
Okay. So we're well fed and what we try to do is to make it very compact because it's Saturday, we have other things that we're doing. Yeah, it's a Saturday and we may have other engagements. We do actually have other engagements. So, when you're flying, there's what you call the initial descent, when you start. So we're starting our initial descent. And there's no other person to do this than a very, very practical person. I actually have 2 senior sisters, but since I met her, I've added one to my list of senior sisters. She's a big sister. She's a professional colleague. She's attained the highest level. I've worked with her very closely over the last 1 year. And when it comes to dispute resolution, and I worked with her in a non-legal role, and it had to do with people, managing people. And the next topic is about disputes. And she's an expert in disputes. She's an arbitrator. She, very hands-on, very practical, and pragmatic as well. So I know I've said a lot, but I have somebody to formally introduce her before I into her role. So I'll bring my colleague Chizoba to introduce the next speaker. So I deliberately left her name out, so Chizoba will do the others.
So should I start with her name? Okay. Good evening, everyone. Good afternoon, everyone. Yes. So, when you see some people's profile, you'll be confused. I think that's what's going on now. So yeah, very impressive one. So I'm starting. So please join me to welcome Mrs. Folashade Alli SAN. So I'm going to read her profile to you, just a little bit about her. So she's a distinguished legal practitioner. She's a member of the Lincolns in London with a remarkable career spanning over 35 years. She has dual qualifications both in England and Nigeria. Her expertise and reputation are highly regarded and recommended in the legal community. She's a chartered arbitrator, and she actively participates in ad hoc and international arbitration proceedings. Her experience includes serving as chairman of arbitral tribunals, sole arbitrator, member of various arbitration panels. She has provided legal counsel, advisory services in complex arbitration disputes across a wide range of industries, from energy and construction to commercial matters. And she's an active member of several reputable and esteemed professional bodies, including the Chartered Institute of Arbitrators, the International Chamber of Commerce, the Nigerian Bar Association. She has functioned in numerous leadership positions. Actually, she has been very helpful to the Nigerian Bar Association on different levels. And so please join me as we welcome her to take this stage. Thank you very much, Maria. Really glad.
So good afternoon, everyone. Nice to be here. I'd like to first of all start by thanking the chairman of the CLE, Mr. Kayode Fabumi, and the chairman of MBA Lagos branch, Mr. BC Makonjola, for inviting me to be part of this continuous legal education training. I know you've had so much. No, I'm not going to sit down. It's fine. Thank you. You've had so much this morning. I wasn't here, but I know the topics. I think I understand your first topic was about contract drafting. Okay, so, and then you've now gone into negotiation strategies. When some of you, I understand some of you are lawyers, majority, but you also own your businesses. Can I know how many people are running those side shows by the side, apart from your law? Anybody here? Thank you for being honest. So, you know, when you finished at law school and you started your training, I'm quite sure you all had these lofty ideas of some wanted to have, even law firms, you have partners, don't you? You must sign agreements. You know, when you start your business, where are my slides? Okay, so when you start your business relationship or you meet someone, it's always a good time to think about disputes. Because in life, you can only know today. And when things are going well, think about the fact that there will be disputes. I'm quite sure you have siblings. Do you fight with your siblings? Exactly. Do you quarrel with your parents? I'm quite sure most of you don't get along with your mom or your dad because they don't want to. And so there will always be disputes. And that's the first thing we all must bear in mind. I listened intensely when my learned colleague, Mr. Ayuli, was talking about negotiation strategies. It's extremely important. It's at that stage where you finally decided that, oh, okay, I want to start this hairdressing salon. I want to start this law practice with your colleague. How many have law firms that are started by themselves? And is it a sole practitioner or you have a partner? So most people start sole and eventually you join. When that person approaches you and says, Folashade, I would like to join you, us to start a partnership, and they have all these lofty ideas. Oh, I just met the MD of ExxonMobil. I have a friend. We have all these lofty, big clients. I think we have a lot going on. We can make it together. You have this expertise. Smile, think about it. All you always think about is always money. How are we sharing 50-50? That's not because that would never be the issue that will cause the quarrel. What will cause the quarrel are things, those undertones that you don't discuss. So I know Mrs. Ufot, Senior Advocate of Nigeria, has also spoken about contract drafting, and I'm quite sure she would have gone into dispute resolution clauses, but I will be going into a lot of detail about the mechanisms and what you need to know about dispute resolution clauses. So that's it. So we're going to start with just talking about what I've just said. Good contracts make good friends. When you're friends, you have contracts, but do you realize that you would disagree? So good friends will still disagree. But when you disagree, what do? And that's what we'll be talking about this morning. So in a nutshell, I'll be going into 4 areas. 1, the various methods of dispute resolution that we have. 2, I'll talk about the role of dispute resolution clauses in contracts. I'll look at the elements of an effective dispute resolution clause, and then I'll go into practicals and tell you what you need to avoid and what you shouldn't avoid. So we're going to start. How many dispute resolution methods do you think we have? Can somebody try? So we all are lawyers, we go to court. How many lawyers do I have here? How many are solicitors? So you all do both, barristers and solicitors. In England, there's a dichotomy, but in Nigeria, it's fused. So I started my practice as a solicitor. I hated court. I thought I did. So I was so adamant I was never going to go to court. So I started by working in Aluko and Oyebode, only did intellectual property, this. And then eventually I got tired. And then I decided I started my arbitration practice. And then when I started arbitration, I thought, well, if I'm now really writing awards, which I'm going to go into, so why can't I go to court? Because at the end of it, as an arbitrator, what do you look at? The evidence of, that's before you. Hence the reason why I now, at old age, went back to litigation. Don't do what I did. But I'm enjoying life. You know why? Because I have the heart of everything. I'm a solicitor, I'm an advocate, and I'm an arbitrator. So I can talk from every angle, and that's the beauty of what I've done. So we're going to look at the different methods. One, when like an ExxonMobil or a Chevron, you don't like paying lawyers. So what they do when there's a dispute, they first of all try to see how they can negotiate with the parties. They won't come to you. Most companies, which are the people we're looking for as clients, they try to first of all see how they can negotiate and resolve that dispute. And so the negotiation strategies that you saw when you were building your business, there's also negotiation strategies that you need to resolve disputes. So when they start, they always have that negotiation mechanism where they would decide that, what's the problem? And they call the customer in. Let's assume it's a building construction dispute. And maybe the contractor, for whatever reason, was supposed to build that building in a year, and is now maybe, is in milestones, which obviously maybe some of us who don't know, when you want to build a house, you might start from foundation and say that I'll pay you, assuming the contract is for $1 million, I'll pay you 200 when you do the foundation. When you finish foundation, I pay you another. So those are milestones. And let's assume it's now 3 months. He was supposed to have finished the foundation by first month. He hasn't. Client is getting a bit worried. They might want to terminate and call the gentleman in. Mr. Yusuf, you told me you were going to finish this contract in one year, and you're supposed to do the foundation within a month. But we're now going to third month, you haven't. That's a negotiation. And to see if really can continue, or you don't have any confidence in him, I might want to terminate. Now, in the event that you actually are successful, that's it. You don't need me. However, so that's the negotiation. We're not going to talk about that because that's easy. Now, the next is conciliation and mediation. The slight difference between the two is that in mediation, you get someone to facilitate open discussion. That's why we have the multi-door courts. Do you all know where it is? Okay. Then conciliation is the same. The difference is that it's more structured. The conciliator tends to be more involved and might give an opinion. A mediator never does. Yours is to just ensure that you try and negotiate. Sorry, talk to them, make sure that there's an environment. When you're so upset, you don't even want to see that person. But when the mediator comes in, there's now an environment where you can actually have a discussion. So there's arbitration and there's litigation. I'll quickly go through just the elements that you need to know for us. So I'm going to be focusing on mediation, arbitration, and litigation. And what is mediation? Mediation is a dispute resolution process. We all call it ADR, alternative dispute resolution, where both parties, with the assistance of a mediator, who is always a neutral third party like myself or you, any one of you can be mediation. And I will encourage that you do that. You know why? It gives you that heart to start knowing what you need. So multi-door courts are always looking for people to be mediators, and it's just doing a course and put your name down as a neutral. It's good for you to start learning, and that's how you learn negotiation skills that we've been talking about. The reason we're here is to tell you the opportunities that you have that are so free. They don't pay much. It might be 20,000 naira, but you learn so much because you learn how to get parties to come out. You might have to separate them. You might have to go into caucus. and then bring them back together. It's really good experience for you guys. So, and what do they do? They identify the issues and try to facilitate. So the mediator is normally any one of you. You must be neutral. You must not know the parties. You always first sign a form, which is a conflict form to confirm that you don't know the parties, because you must always remain neutral. The only disadvantage about a mediator is that they cannot give judgment. So where, what's your name, ma'am? Oluwatobi and myself have a dispute, and we go before a mediator, which is Abdurrahman. So he mediates. Well, if we resolve, it becomes a settlement agreement, and you can register in court. However, if you do not, what did you say? Fantastic. I think she's very brilliant. So if, unfortunately, Mr. Abdurrahman is unable to resolve that dispute, there's nothing you can do. That's the disadvantage. He can't force us. He can only assist to ensure that there's a communication. And if that communication results into a settlement agreement, then it becomes a judgment which can be sued upon. So why do we choose mediation? I believe it's fast, because one, you can, if you have a good mediator, they will ensure that that dispute is resolved within a week or two, if parties are willing. So, and if they're unable to, they send it back to court. And that's the advantage. It's fast. One, especially for business relationship that you want to continue, you know, you can resolve that particular dispute. The example I gave initially about that building construction, you know, if you go through mediation as an example, and you're able to resolve that issue of the foundation, you can continue, and that builder might still be able to continue without you actually becoming enemies. So and then you maintain your confidentiality, because it's only between the three of you. It's not like in open court. So it has a lot of advantages. One, you promote your relationship, you continue, because you can continue that relationship if both of you have that neutral person that actually talks to both of you that, look, this is not worth, killing yourself. And then obviously it must be mutual. If you both don't agree, it's never a win-win situation, unfortunately, in mediation, or in most times when you quarrel. When you quarrel with your siblings at home, at most of the time, your mom is being careful and doesn't really want to say this, but at times you just have to, give up something. So we must learn, in most times where there's a dispute, somebody has to learn to sort of, not insist on their own point of view. And it supports problem solving rather than finding fault. So you try to resolve. And the essence of going there is because both of you have decided that you want to make it work. And you must have that at the back of your mind. When you start saying you did this, you did this, you did that, can never resolve. So it's really to promote that resolution. And that's the essence why you went before an impartial and independent person who is a neutral, a third party, who can wear that hat of trying to let both of you see reason. So remember what I said about mediation. The most important thing is that it is a platform for discussion. Mediator is not a judge. So, and it's flexible. And that's really what mediation is about. Then we're not going to go, I'll just briefly, because I don't want to dwell on this. I want to go into why I'm here. Disadvantage of mediation is that it's not binding until there's a settlement, which I've told you. Potential for it not to be resolved, because Abdurrahman cannot force you to resolve it. Any party can be so upset and walk out. And I've seen this happen. It's not suitable for every dispute. You can't have a crime. Somebody can't commit rape and you say you want to mediate. It's mostly for commercial, disputes. And obviously limited legal guidance, because at times you don't have to have a lawyer to go for mediation. At times, most banks do. Your lawyers can go with you, but it's not compulsory. So that's really what arbitration is about. Conciliation is just slightly, it's the same thing. The difference is that the conciliator tends to push a bit and could actually give an opinion. By the end of the day, it's still not binding. Arbitration which is who I am. I'm an arbitrator. It's a method, it's also an ADR, where parties submit to their dispute, to an impartial panel. And at the end of the day, who knows when eventually we have all that, we've gone through the reference, and I want to give my decision. What's it called? Can we clap for ourselves? So we all know what arbitration is about. So basically, it's submitting to a neutral panel. The panel can be one, or can we have two? Who said yes? So it can only be one or two. And the reason is that, and this is where we're going to go to, the dispute resolution clause determines how many it should be. So, and normally, now we have a new act. We used to have the ACA before, Arbitration and Conciliation Act, which now, unfortunately for us, we now have a more recent and robust Arbitration and Mediation Act, which deals with all the flaws that we used to have in the ACA. And it could be institutional. Ad hoc means that when you decide you want to appoint Mrs. Ali in Nigeria, and at times it could be institutional means that when it's that institute that appoints, like ICC. Who knows the other institutes that we have? Chartered Institute, LCIA, there's NICAB. Thank you. So we have so many institutions here, which I'll explain to you later. And normally it's suitable only for commercial disputes. Tax matters, are they arbitrable? Thank you. You guys are brilliant. How about criminal? How about matrimonial? Thank you. A round of applause for all of us. So I've told you who an arbitrator is. It's basically any one of you can be an arbitration. Can an engineer be an arbitrator if you don't have a legal background? Fantastic. Can a surveyor be? Anyone can be an arbitration. That's the beauty of arbitration. You don't need to have a legal mind. So there's this conception about us lawyers thinking that we're the only ones. Not really. Because there are disputes that has to do with technicalities. And if you let's assume that's something to do with I'm just trying to think of a very complex area that I don't have engineering. Yeah, thank you. And then there's even one I'm doing now, a construction one, but you haven't gone through, and it's so technical. Engineering, they're bringing all this, and you appointed Mrs. Ali. I will spend more time to try and understand. Whereas if you had recruited someone that had that background as an engineer, and engineering dispute. So when you're doing energy, come to me, that's my area, because I know it. So what I'm trying to say is that you must be careful about who you appoint. And we'll talk about that. So the reason why arbitration is so, it's become very, very popular, and statistics have shown that most institutions internationally are going for arbitration because it's fast, it's confidential. Two, you deal with your issues without all those, bottlenecks of court process. So obviously, if you don't have your arbitration, your dispute resolution clause in writing, can we now later on decide that we want to go for arbitration? Thank you. How? What do we do? Who said yes? What do you do if it's oral? Yeah, so that's, if two people are fighting, can you agree? Most of the time you won't. That's waste of time. So if I decide that I entered into this business relationship, with someone, and we did not agree, when there's a dispute, he might decide that he wants court. I would say I want arbitration. That could take like a month to resolve. That's why it's always advisable that it must be in writing. Even if a submission agreement still must be in writing. Thank you. And must be agreed. So I've said all this. It's enforceable. It's flexible. So please, that's why we choose arbitration. Now, the disadvantage is we don't come cheap. And that's why I want you to become arbitration. It could be very lucrative because it depends on the amount in dispute. So if it's $1 million dispute, I charge based on the amount, and the skills are there. So there's nothing to argue. You appoint me, I just go to the skill. If you go to ICC, Chartered Institute has their skill. You put the amount in dispute, tells you how much you should charge. So at times it could be expensive, but commercial-minded people don't mind that cost because the cost of you being in court is much. but we always waive it. Most people don't, I mean, you would be flexible with the fees, but the thing is that there's a guidance, unlike courts. I mean, apart once you pay your fee, relevant fees, judges are not paid by you. It's public. So it could be high, it could be expensive. It's not suitable, as I've told you, for all disputes. There's the risk, which is at times, if you're unfortunate to choose someone that's biased, and that's why at times in England, they do a shopping and find out about that person before they appoint the person. And it might not be relating to the dispute itself. It might be that person's, about a particular issue. So you need to be very careful when you're choosing your arbitrator to find out who they are, the dispute in question, and probably their thinking about that particular issue. And obviously, it's limited in scope. At times, I mean, for me, these days with the AMA, the likelihood of going to court has been streamlined, but there's still that door, a window that's been opened that you can still eventually go to appeal against it. And obviously, there's limited discovery rights. But generally, arbitration is really one of the, I would say, efficient ways of resolving commercial disputes, but it's not suitable for all disputes. So why do we go for litigation? What is litigation? We all know what litigation is. It's the traditional system of resolving disputes, which we are all used to, and it's through the courts, and obviously it's governed by the laws. So litigation is the way to go. It's always been there and will always be there. Even we arbitrators need them, because there are some things I would not be able to. Injunction, special, so you still need the court to support. If at the end of the day, you had decided in your arbitration clause on who you want to appoint and parties are unable to, at times the court has to come in. So we also still need the support. We cannot survive without the courts. When you want to enforce your award, where do you go? So I just want you to understand that the courts will always be there. So why do we choose litigation? There's some disputes I just have to go to court for. It's more structured. It has a binding and enforceable structure, because once the judgment has been given, except obviously in Nigeria, and you lawyers are part of it, that you always think you must appeal, it is binding and is enforceable. You have a right to appeal, as we all know, from High Court to Court of Appeal to Supreme Court, but please, let's try to make sure we advise our clients. We have to stop this thinking that, you must appeal when the judgment is not in your favor. Obviously, in courts, you must not need a lawyer. Arbitration, not necessarily. If you know as I told you, a surveyor, an engineer, a banker can be an arbitrator. Now, depending on the disputes, you don't really need a lawyer. Obviously, it's public and there's transparency, and obviously there's discovery process. So I'm not going to dwell on litigation because we're all lawyers here, and that's not why we're here. I just thought it was necessary for us to know the different types of methods of dispute resolution before we now go into why we're here. Obviously, it could be costly because when you appoint someone like me, an SAN, at times our fees are not really cheap. It's adversarial. At times it's time consuming because of the tactics of us lawyers, always asking for adjournments and you're not ready. We must try. Our reputation is not very good, so we need to change it. Limited control, and at times it could be complex depending on how you guys decide that you want to make your case complex, which is why you earn your fees. So in a nutshell, I thought it was necessary to have a comparison for us to look at, since I've told you what arbitration, mediation, litigation is. So in a nutshell, mediation, as I told you, if there's no settlement agreement, there's no mediation. It's not formal. So Abdurrahman can be, the way he's going to conduct is different from how there are no rules. Although now we have an AMA, Arbitration and Mediation Act, which has codified mediation, and there's some guidelines, but it's not strictly followed. It's voluntary. If you don't want to, nobody can force you to go to mediation. The rules of evidence at all does not apply. You can't impose the outcomes except you agree. and obviously it's private. Arbitration can be it's binding and it's enforceable. New York Convention, the advantage of even arbitration is that once it's in a country like ours, that's part of, and you can enforce it in over 170 countries that are part of the New York Convention. It's more formal, although there's still lacks some flexibility in the terms of, in the way it is, but there's some process. Before you can start, you must have preliminary meeting, you must appoint, do you understand? So it's still a bit formal, but Mrs. Leonard Silk, how are you? Same here. The rules of evidence obviously applies, and the outcome is such that the outcome of the award actually more or less lays down what the outcomes will be. And litigation, as I've told you, is binding, it's formal, it's not voluntary once they take you to court, and the rules of evidence applies outcome. So now we go to why we're here. We've looked at the various methods, and now we're going to go into what really is dispute resolution. So now that we've gone into, like, I thought that was essential to have all these preliminaries. What is dispute resolution clause? Which is why I'm here. You know, when you have an agreement, an arbitration agreement, a shareholders agreement, any type of agreement, there must be a clause that talks about how you intend to resolve your dispute. And that, in a nutshell, is a dispute resolution clause. That, for me, that clause is so important and is so critical, because when parties are discussing how they want to enter into contract and they're discussing how they want to share their money and dividend, they don't normally think about dispute resolution and just put clauses, one-liner, not well drafted, that at the end of the day is so complex and at times it's so ambiguous that when the dispute arises, you lawyers that drafted it now have a problem as to, okay, so what is this clause? How do you interpret it? So my role today is to teach each and every one of you how not to draft a clause that can lead you into problem. We're all lawyers here. And at times it's our fault, it's the lawyers that draft these clauses that are so ambiguous and create problems for the clients because the client doesn't know better. Do you want arbitration? Yes, and you just put it. You didn't say if it's one arbitrator or three. And then now you're now looking at the default provisions. Thank God now AMA allows for one. But before, a small dispute relating to a tenancy agreement of 2 million naira, you appoint 3 arbitrators. Recipe for disaster. So the dispute is 1 million. You're appointing me, Mr. Johnson, and Mr. Fabumi. Unfortunately, Leonard Silk, Mr. Candide-Johnson. So that's why we need to be careful. So we're going to look at the role of dispute resolution clauses in contracts and what we need to avoid and the pitfalls. So it's a dispute resolution clause plays a critical role by setting out a predefined mechanism for handling disagreements that may arise between the parties. It must be predetermined. That's, for me, that's the key. You guys determine how you want that dispute resolved, nobody else. And you must be careful when you draft. So what's the importance? The importance of dispute resolution are unlimited, because when you make that mistake, you know, you set your client's business and a lot of things, you know, just do not go well. So we need to be very careful. One, it minimizes uncertainty because you have predefined how you want that contract to be resolved. So it's not that when the dispute now arises, you're now thinking, okay, are we going to go to multi-door court first? Am I going to Chartered Institute of Arbitrators, or is it LCIA to be the appointing body? You've predetermined how you want that contract resolved. So there can never be any form of ambiguity. Therefore, you've minimized the risk. 2, it promotes efficiency because you're so efficient and the dispute will be resolved. You got immediately, you trigger, there's a dispute, you just trigger whatever mechanism you've decided that you want to follow and you go for it. Then it provides flexibility because now obviously you know where you're going and you move on. then it ensures that there's confidentiality amongst, because if you've decided that you don't want to go to court, if it's mediation you want to go to, you go for it, especially depending on the type of dispute. Then it safeguards your relationship, which is what happened with Abdurrahman earlier on. He resolved our dispute and we moved on. And it ensures that obviously when you're done, you can enforce. It provides speed and you know where you're going. So basically, that's the reason why it is important that you have a predetermined way of resolving your disputes and you just move on. So now that we've done all this, we're going to now look at the key elements that are essential in your dispute resolution clause. When you want to draft, what do you put in it? What do you say? And how do you say it? So one, in your dispute resolution clause, you say in the event that there's a dispute, you must choose where you want to. So I live in Lagos, and I put that my dispute resolution clause, the forum should be London. You haven't thought about the fact that this dispute is only for 10 million naira. The ticket to London is how much? And then you want to take Mr. Candide-Johnson and Folashade Alli. Is it necessary? So you must be careful. At times you just put things, maybe you just took the sample that you saw in LCIA or in Chartered Institute UK's website, and you just pasted it. In a Nigerian dispute, why are we choosing London? Do you understand? So you need to be careful when you just, because you don't, at times people don't think, but so you look at your dispute, look at all, and then decide on the forum. Forum should be Lagos. Don't put Abuja. If the parties are here and the subject matter, because flights to Abuja are not cheap anymore, are they? So please be careful, because I've had a dispute before where all of us were in Lagos and we had to go to Abuja because that was what the parties wanted, until we all had to call the parties that, do you want to review this? Or just one party is in Abia State. So what I'm trying to say is that forum doesn't actually mean it must be outside of Nigeria. Even within Nigeria, you need to be careful and don't put things that are not realistic. And the governing law, obviously, make sure you look at your contract and decide what your governing law should is. And obviously you must define your scope, because my authority as an arbitrator or even as it must be well defined when you're drafting. And I'm going to go into details about what I mean by that. So the scope is what type of dispute should that clause cover? So there must be a perimeter and I must not go outside. If I go outside, what's it called? If there's a scope that has been well defined and I now decide to resolve my disputes or to arbitrate outside of that scope, what have I done? Sorry? What have I done? Also, I don't have a jurisdiction. That scope defines what? It defines my jurisdiction. Thank you very much. And there should be specific clauses to exclude what is what should be excluded, and what basically your scope should be well defined, and that is extremely important in your dispute resolution clause. And obviously, you must state the language. If I say that I want the disputes to be resolved in Arabic, and none of you speak Arabic, the venue should be stated. So, and the language, all these things must be stated and must be clearly stated, but we're going to go into it. So how, and you must state, obviously, if you want one arbitrator, if you want 10. Can you have 10? From what I told you, how many can we have? One or? And the 3 is called a panel? Okay, a tribunal, thank you. So how do you appoint? The parties can appoint or? Okay, thank you. So the institutions are, I've told you who they are. ICC, Chartered Institute, there's so many, but we'll go into, and obviously I've told you the number of panels. Now, in the event that there's always meant to be something called a default. So in the event that you're unable to appoint, so I appointed Mrs. Rosevival, Mr. Chukwumeri, Mr. Fabumi, I gave all the lists. The other side, everybody I appointed, he refused. The other side, you just had problem with both. Eventually, you must have a default mechanism that in the event that you're unable to appoint that sole arbitrator, what do you do? If you don't put it in, that might take you 6 months just to choose, and that's wasting time. And that's cost. Especially for business-minded people, it could cost a lot of money. That's why you should put in that your default clause that in the event that parties are unable to agree on the appointment within 30 days, they should go to the president or chairman of Chartered Institute of Arbitrators. Remember to say which one, or ICC, say whoever it is, LCIA, but you must state who will be the default or court. And obviously, I've told you why it's essential to state the qualifications, because there are times where the dispute is a specialized one. So now we're going to now go into what is dispute resolution clauses. I explained to you earlier on what most IOCs, international organizations, even corporates do. They don't just go straight and say that they want to go to arbitration. They might decide first that there must be a negotiation, or you must put a time frame. In the event that the negotiation fails, you do what? Mediation. You might put a time frame before you now decide that arbitration is a last, and it's called multi-tier dispute resolution. So, but it's for big contracts. And I'll just show you an example of a multi-tier dispute resolution clause, which says any dispute relating to this agreement which cannot be resolved by negotiation between the parties within 10 days, 30 days, but make sure you put the number of days by either party giving notice to the other that the dispute has arisen shall be submitted to mediation. So in the event that they're unable to resolve by negotiation, they go to mediation. Pursuant to, and put the rules, obviously, and failing settlement of that dispute by mediation within another 30 days, the dispute shall be submitted by any party for final resolution by arbitration and you can now say if you want 1 arbitrator or 3, conducted in Lagos, and you put the language in accordance with the rules of arbitration. So that's basically, you can see that it states all the levels, but it's not too cumbersome that you're now confused. So we must be careful when we draft. And that's a typical multi-tier arbitration, dispute resolution clause. So now that we've looked at the dispute resolution clauses, we're now going to go into the practical examples. So what I want to do is, there's something called the 7 deadly sins. And those are the sins that we all commit every day, that at times causes problems for you and me in dispute resolution. When you're ambiguous, when you don't pay attention to details, when you over specify, we're unrealistic, and I'll now explain each one in detail, because you need to be very, very careful when you draft. And these are the pitfalls, and these are the things I think you should look out for when you're drafting. 1, when you fail to state clearly that the parties have agreed to be bound by arbitration. Now look at an example. In the event of a dispute, the parties may seek to resolve the matter through arbitration or other mutually acceptable means. What's wrong with that clause? What is vague? Thank you. It says other, so it means that you haven't said arbitration. So, if you look at this without really thinking, you think it's okay. But that's small, that's slight other mutually acceptable. How about if you don't agree? So, that is because it's ambiguous and it can lead to delay in resolving your disputes. So an example of a non-equivocating clause is any dispute arising under or related to this agreement shall be resolved exclusively through binding arbitration in accordance with the rules of you know, wherever, if it's chartered institute. So you can see that this states clearly that you want your contract or your dispute to be resolved through arbitration, and it will state the rules. So please, let's be careful when we draft. When you don't pay attention to detail, and some of us fall into that category. When you draft a dispute resolution clause that doesn't have sufficient attention, and this always consider the best dispute resolution process suitable for the transaction and for the client. So, and so as an example, you know, you have a construction dispute and you neglect to state that you want that person to be a qualified, maybe chartered surveyor. You don't state, you just say that, you know, it's a construction, and just say that when the dispute arises, you appoint a sole arbitrator. You've said everything in accordance with the rules. That's a good arbitration clause, but you have not specified that that person must have the qualification that you need, because you know that this is not just a normal landlord and tenant sale or purchase agreement that doesn't need any qualification. So when it's now time to appoint, you can't insist that you want a surveyor because it was not in your agreement, was it? So that's not paying attention to the contract, and that's not paying attention to your clients, because now you've put your client in a position where they now appoint someone that doesn't have the qualification, which happened in an arbitration I was involved in, and was a disaster. Unfortunately, the arbitrator we chose did not have an iota of experience in the area in dispute. And it just caused unnecessary delay. You know what we had to do? We had to appoint an expert. That's what additional, which was most unnecessary if we had appointed someone that had the relevant skills and experience and qualification. So we must pay attention when we draft. Then when you omit crucial elements from your dispute resolution clause, remember I told you earlier on, the goal of you drafting is that you don't want to start going to court to interpret who should we choose, who shouldn't we choose. So when you don't pay attention and you omit those vital information, it's just recipe for delay. You know, any dispute between the parties shall be resolved through arbitration. What does that mean? Can somebody tell me? Through arbitration, it's a good clause. You've said that you want arbitration, but you haven't said if it's 1 or 3. So you can now decide, now that we have the AMA, it's probably easier. But before, we had our default provision in the Arbitration and Conciliation Act was 3. And this is just a simple dispute that I don't need a 3-man panel. So we must be careful, you know, when we draft. And then when we now emphasize, and you put everything on that, because Ms. Ali has told you that you must make sure you put everything. The one that's not necessary, you put gari, you put water, you put sugar and milk, everything inside. So that by the time you have that recipe that even you don't understand. So we must be careful. Let me just show you an example. And it's a very nice one, but if somebody can explain to me what this means. The arbitration shall be conducted by 3 arbitrators, each of whom must be fluent in Hausa and have at least 20 years experience in the repair of better marks players. One arbitrator serving as chairman must be an expert in Nigerian telecommunications laws from the 1980s and have published research on regulation of landline switchboards in rural areas. So we wanted to put qualification because I told you to, but it's a lot of problem that you are looking for. I don't know if you will not have any arbitrator that will have that experience. So by the time you are searching the internet, looking for this arbitrator, the dispute time has gone. So please, I said you should specify, but I didn't say you should now go and start putting things that you can't even find in the internet. The internet will blow. So please, let's be careful. You know, when we're drafting, draft well, specify, but please be realistic. Look at the contract before you start putting the qualification that's not necessary. Don't ask for an arbitrator that has 30 years experience, because only people like Mr. Candide-Johnson SAN that have that. Some of us don't have it. So please, let's be careful so that all the work doesn't go to him alone. So realistic expectations. Include realistic timelines and provisions. Be practical with the timeline. Because I've had one experience like that before, which I'll tell you. Let's read this and then you tell me what you think. The claimant shall name his arbitrator upon commencing the proceedings. Very good. Respondent will then appoint his arbitrator within 7 days. And the two selected arbitrators will choose a third one who will act as the chairman within 7 days. Hearings will begin within 15 days of selecting the third arbitrator and conclude within 3 days. Arbitrator will issue the award within 7 days after hearing concludes. We're done. Can we do it? Is it possible? It's not possible because you said you want to finish. And I've seen one that said 60 days. It's not practical. And then you're not asking parties, the parties, even that 60 days, you're still asking them, preliminary meeting, the call meeting, agree on fees. We're going back and forth. 60 days has gone. So please, timeline is good, but put realistic timelines, not the ones that can never happen. Litigation envy, include provisions that inappropriately incorporate court rules. So in the process of you trying to, draft that clause, I'll show you what I mean. This arbitration will be conducted in accordance with civil procedure rules of Nigeria. Arbitration, but you have now decided that you love litigation. So we must put that litigation inside. Serious, but it's actually, I've seen some agreements that at times unknowingly we make life difficult for our clients. And that's why, MBA Lagos has come to try and tell us that we need to be careful, and they're training you so that, we can start wearing the hat of, when you're dealing with international lawyers, they're proud of you because your attention to detail, it's a par. So this is not, you shouldn't take these opportunities for granted. You're being given a platform to know what you need to avoid. And please, it's not funny, but these things actually do happen, and they just cause unnecessary delay and unnecessary costs that could have been avoided if the lawyer that drafted paid attention. So, we have overreaching provisions also when you're tilting the dispute resolution to favor your clients. Remember, the goal is to act fairly. So what I'm trying to say in a nutshell is that in anything we're doing, when you're drafting, just draft. Draft that contract. We've been told about what you look out for when you're drafting, as you're thinking about the monetary aspect and the obligations, duties of the parties. Remember that this clause is extremely critical because there will always be disputes. And that's why you're a lawyer, because we're not praying for dispute, but it will happen. There's nothing you can do about that. Disputes will occur. When it occurs, the question is that how do we resolve it? And how do you ensure that they don't now say that, which law firm drafted that? And say, it's the law firm of, Madam, what's your name? So it's not going to be my law firm in Jesus' name. So, we need to be careful because your reputation then goes down. So what are the consequences of drafting a badly drafted, dispute resolution clause? One, as I've told you, it causes unnecessary delay in resolving the dispute. Based on financial resources, you're just wasting money. And obviously, you now, from nowhere, now have to go to court, which has happened so many times too. When you now cannot resolve or you're disputing, the court now comes, and then when you go to court, will they answer in 1 week? 1 year, you're still trying to resolve that dispute of how to appoint an arbitrator. And when they appoint it, before the parties might now say that, so I don't agree. The court was biased. Who would the court appoint? It's just that they know. I might not be your choice. I'm in one already. So I won't want to say more than that. So you need to be careful. And that's because the contract was badly drafted. So the court, and honestly, the courts are really trying these days. The approach to courts at times is good. At times, when you have, and that's why I'm happy with all this. We're really training the judges. Before, they really were anti-arbitration, but now dispute resolution clauses, they actually now understand that we're not in competition, and we're working together just to ensure that disputes are resolved. So I think we should just move to I want to now go into some samples, and then we're going to discuss how we can. How many more minutes do I have? I don't have a time, so I just want to know. What's the time now? I don't have 10 minutes. I still have. So any dispute, what's the time? Ask for time. You're now changing. Mr. Candide-Johnson told you to change the time. What's the time? Okay, so okay, let's go. Right? So let's go. Any disputes arising from or in connection with this agreement shall be referred to and resolved by binding arbitration in accordance with the arbitration and constitutions. This is an old one. Oh, hello. Okay, and this shall be conducted in English. The arbitration shall be conducted by a panel of 3, with each appointing 1 arbitrator and the 2 appointed arbitrators selecting a 3rd arbitrator who shall serve as the presiding arbitrator. If a party fails to appoint an arbitrator within 30 days of a request to do so, the arbitrator shall be appointed by the relevant authority in accordance with the Act. The final decision of the arbitrator shall be final and binding on both parties, and each party shall bear its own costs and fees. Can somebody tell me what is wrong in this clause? Can somebody see anything? Can anybody tell me what is wrong that you don't like, or you think this is fantastic? I've seen 1 or 2 things. Can you speak? Yes. Yeah, then.
Okay, okay, I say the first thing I noticed is that the Arbitration Act is the old act. And then it talked about each arbitrator appointing 1 arbitrator. Yeah, okay, that's
for me, is this. Which authority is that? It was not. So you understand? I just wanted you to see that you can actually draft a very nice one. Everything here is good. But there's just one problem. Where there's a problem now, where do they go to? It's vague. Thank you. Let's go. I have 2 more minutes. Yes, please.
Okay, my said each party will appoint an arbitrator and the 2 arbitrators will appoint the 3rd arbitrator. So my question is, who is going to be liable for the cost of the 3rd arbitrator?
No, normally that is the panel. So when they're chosen, all right. No arbitrator is paid. Oh, I'm sorry. Hello. Oh, I'm so sorry. So when the arbitrators are appointed and there's a panel of 3, the fees are paid by both parties. It's not like I pay for the person appointed, the person, no. It's a panel. The panel decides the fees based on the amount in dispute, and it's paid by both parties. However, did you see this here? When it says that, so already there's a law called what follows what? So already now that it doesn't, you've already put here. You've shortchanged your clients. You said here that. Do you know what that means? Even when you win, you will pay your cost. Please be careful. Thank you. Next one. Because of time, these are just sample. I'll show you I can share my slides of typical well-drafted clauses that are on the websites of the various institutes that we must follow. I'll only read one. Let's look at the LCIA one. Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under the LCIA rules, which rules are deemed to be incorporated by referencing to this clause. Anything we're looking for that's not there, the rules are there. So please, when you're not sure, let's try and get the relevant clauses from the institutes. But these are institute-related appointments and not ad hoc. So in summary, the things that you need to look for in your arbitration resolution, dispute resolution clause, it must be clear, extremely clear as to what you're saying. Let's not be vague, and make sure that it mentions the 5 things I said: the forum, the venue, the language are all stated, clarity in terms of all the things that must be there, and make sure that you can ensure eventually that is enforceable. It's extremely important that we do that. Now I'm going to go into questions. I understand I don't have much time. So do you have questions for me, or I should ask you questions? Thank you. Yes, ma'am. Thank you. Thank you. Thank you.
For example, a very difficult partner on the other side, who is the stronger party, stronger negotiating party? All right, thank you. And the other party is insisting that, for example, the law of US, Florida would, govern the transaction, and the venue of arbitration is going to be Florida. And your client is asking you, is there anything you can do? So your client is the weaker party. You have told your client that excuse the odds against your client. If there's a dispute, the client has to go over to Florida. But what can you do in that situation?
That's basically what I believe Mr. Ayuli was trying to talk about negotiation skills. Those are issues you need to resolve whilst you're drafting. I think the first question would be, the subject matter of the contract. Where is it based? Is it in Lagos? Are all the parties here? No. In terms of the contract, the subject matter of the dispute. So is this about a land in Lagos? Is it about some owner? Importation of software. And they're not asking you, if you don't think it's supposed to, that it's going to increase and doesn't have any relationship with Florida, I think you should let them know. You should let the party know, but if it's going to, I personally wouldn't, if they don't have, there's no relationship with Florida. You're importing something and I'm quite sure if you explain, the problem most of the time is they might not have confidence in your country. Look for another neutral. So you might suggest that, why don't we go to London if you think that's nearer? But in the circumstances, you might not be able to insist on Nigeria, unfortunately. At times, people don't have confidence, but there's nothing you can do about that. Yes, please. It's your personal, you have a dispute. You're in a situation like that now. We talk after.
Well, I think it's better. Okay.
Yeah, please. I need to give other people. Yeah.
Any more? Okay.
Yes. So my question is in and around that issue of the forum for resolution. You've already addressed the fact that you can look for an alternative, a neutral.
Neutral, yes.
There is the issue of choice of law.
Mm-hmm.
And there's also this knotty issue about how you, okay, so where you have these clauses in some agreements, they call it, is it lex citus? I'm trying to remember the Latin phrase, but it talks about where the contract itself is to be carried out.
Substantive law.
And what effect it would have on your venue for dispute resolution. I don't know if there's something you can guide us to on how to navigate that very knotty issue.
No problem. Let me just ask
Sorry, it seems this question that has a sort of similar. So please, if you want to ask something similar to that, she would address forum. So let's look for any other area that.
Yes. I have a question that's very similar to that.
So it's okay. Let's take another area. So
yes, my question is.
It's similar to today. Okay.
Yes, slightly similar. So.
Don't worry. Let's go to the next question, please.
In a situation where maybe the value of the contract is not much, and one party is importing from China, or maybe in Abuja, the other party is in Lagos, and you know your client doesn't have the capacity to move to Abuja to negotiate, can you make the arbitration clause to be virtual? Now, in the sense that parties can involve an arbitrator that will oversee the arbitration process virtually.
That's the hearing. That's different.
Yes, ma'am.
That's different.
Yes,
Yeah,
ma'am.
you can.
And then choose a particular place, the particular law you want to apply, but make it
There's no
virtual.
law in Abuja and Lagos. It's the same law.
Assuming you, for enforcement sake,
Okay.
can you make the hearing to be virtual in the agreement?
Yes.
Okay, thank you, ma'am.
I'll answer you. I'll answer. Is that all? You said take the. Sorry.
Is this semaphore?
No. Thank you, Leonard.
Yes.
Thank you, Leonard, for this beautiful presentation. There's a scenario I want to talk about. To what extent, my name is Nonso, by the way. To what extent you made mention of that lawyers should be mindful about not putting too much in the clause. Now, I'll give you a typical scenario. We had an arbitration where two former colleagues were appointed as members of a panel. The two lawyers used to work in the law firm. Then one resigned and joined in-house. So the one that was in-house was the chairman of the panel, and then appointed someone who used to work in the same firm as one of the panel. And an objection was raised, which was overruled. So to what extent can one be guided in drafting a clause? Can one really go to that point of saying to the detail that such should not happen? Because the matter is in court now. It's actually Society of Maritime Arbitration in New York. You know, two persons who used to work in the law firm. So we raised an objection, and that was overruled.
You should have come to me.
No. What I'm trying to say is that it is not about discussing the personal matter. Yes, but to what extent, just for the benefit of others, because it's been sorted in court. Yes, to what extent can one go in that?
Thank you. Okay, so let me just quickly address one at a time. I'll start with you. So that should not be an issue at all because there are guidelines. IBA has guidelines as to what is acceptable and what is not. There's red, orange, and green list. So you see there's some that are a no-no, which is your red. When I'm appointing my brother or my relation. So they have the list of those, the red list says the relationships that are not acceptable and you cannot waive. So they're non-waivable, you cannot. The orange list, it depends. So as an example, I used to work in a Lukanoye body. 20 or 15 years after I was appointed, I have a duty to disclose to the parties that, hey guys, I just want to have disclosure. I used to work for a Lukanoye body 15 years ago. The rule says you cannot appoint somebody that used to work in your firm or 3 years. I think it's 3 or so. And mine was so immediate because I disclosed. The party said, well, the rules allow it. You can. The IBA rules allow it because of conflict. But if you've so it actually says the number of years that you cannot take up employment. So in your case, if you had looked at the IBA rules, all the relationships are there. What is acceptable? And the green is obviously the ones that you don't even need to disclose. So what you should have done was to see what category you fall under the IBA rules. It's a guide, but it's a good guide that's used universally. And you now decide on, how to go. So basically that's what it is. Your guidelines is what helps you. And also other institutes now also have those guidelines. But I always recommend IBA, International Bar Association guidelines. Now relating to the issue of substantive law, governing law, venue, we must be careful. The venue for your hearing is not the same as your governing law. So what that gentleman is asking is this. We have arbitration laws as well stated. When you appoint me as the arbitrator, especially in this day and age of technology, very, very soon, the issue of venue is becoming, especially even the international ones, preliminary meetings are hardly heard in person anymore. It's normally physically, it's normally heard virtually. That is hearing, that's not your venue. You understand? The venue is, if they say that, the venue is Lagos. Even Lagos, does it say that it must be international, what's it called, intercontinental or Folashade Alli's law firm or CIR? The arbitrators decide on where that hearing will take place. And that hearing could be virtual. And these days, that's the norm. So that sort of answers your question. However, the law is the law. If you say that you want the law of Nigeria to govern, that's the governing law. At times, the procedure, the rules will now be, so if I say ACA, as an example, the rules of, AMA now, the rules of Arbitration and Mediation Act would govern the procedure that we are going to use, not the rules of Hamburg, or do you understand? Those are the rules. But however, there's also something called substantive, which is where you're going. And at times, and the choice of French, especially when you have cross-border disputes, is extremely, extremely difficult. And you must be careful. It's beyond the scope of what we can discuss here because it's a day's topic. But for the purpose of this discussion, what you need to know for now, your governing law, which is the law you want to govern a contract that is situated in Nigeria that has to do with Nigerian roots. But because you've chosen Nigeria, doesn't mean that you cannot have your venue. You understand? So you need to be careful. Venue is different from the law. And then when you now come to the procedure and other substantive issues, it can actually still be different. But I think what we're mixing venue, what I see here is that people are mixing what venue is and the law. I hope I've been able to clarify some of your whatever. Then I can now go into what is substantive, what is the government, but I don't think we have the time yet. I hope I've not confused you.
So you see why I've adopted her as my big sister. So she's contributed immensely, like was earlier said, to NBA, Lagos and National. And I'm sure she's had a few of this, but it's just to show our appreciation to her. So my colleague, Afam, will present this to her. A gift from the branch.
We're going to now have a lot of fun. The next speaker, even have not been given the task. Someone is my mentor. Mr. Johnson has so much wealth of experience. I can't wait to get going.
Okay. Okay, so Elizabeth is here. Okay, so just like the learners seek sort of pre-introduced the final speaker. So now we are now in our final descent, and we've had a very lovely ride. Have we had turbulence? No turbulence, smooth ride all the way? Good, good, good. So Lenel Silk, I don't know if you remember this, but the year must have been 2000. There was a transaction as a young lawyer that I was involved in, and Alhaji Sulaiman, 23 Tony Anibo Street. Yeah, yes. So I was a young lawyer that was assigned the task of closing that deal. And it was a sort of a complicated transaction somewhat, a lot of emotions here and there. And Lenel Silk was the lawyer on the other side. And he gave us a deadline. I think it was 4 p.m. And you know, at the time, there was no computer. You had to go to the, what do you call it, cyber cafe and stuff to get your things done. So I had to run to his office at Chatham Street. And I ran, and I was mindful of the 4 o'clock time. And by the time I got there, I was panting. And then he looked at me, looked at his time, said, "Oh, you're right on time." And, you know, and ever since that day, you know, one of the things I learned from that transaction is, you know, no. you know, the ethics of our profession, there are certain things that we must just do as lawyers. And funnily, that day, I had malaria. But one of the things I pride myself when I review myself is closing that transaction. If you recall, sir, they gave a discount. There was a huge discount that was given, And, I mean, on the other side, they didn't really want to do it, but, they had agreed to it. And if I didn't meet that deadline, that deal would have been off. And for me, it taught me a lot of things. 20-something years on, I still remember that transaction. So when your name came up as the tutor for the, or the facilitator for the ethics in drafting, I knew that justice will be done. And of course, I've known what you've been doing all along. So thank you very much for your service to us. And we hope that this final session will be bath. And I think there's one topic, there's one question they asked that sort of touched on ethics as well. Even though Leonard Sick had spoken about the red flag and the green flag, but in some instances, you may not have that privilege of knowing the IBA regulations. So it's also a little bit about ethics. Even if the guideline doesn't say it expressly, as lawyers, what is expected of us ethically in contract? So I'll leave it to you. Oh, sorry. I think she's meant to introduce it properly so that it can properly introduce it. So Elizabeth, please come forward.
I count the great privilege to read the profile of our next speaker, the distinguished Leonard Silk, Mr. Johnson. Leonard Silk is the senior partner at Candide-Johnson Law and Strachan Partners, a leading commercial law firm in Lagos and Abuja, with a substantial presence across Nigeria. Throughout his career, he has been continuously engaged as lead counsel in high-profile commercial and public policy disputes across Nigerian courts. He has also served as either counsel or arbitrator in numerous domestic and international commercial arbitrations across industries, including maritime, petroleum, banking, and construction. In addition, the Leonard Silk brings remarkable expertise in complex commercial transactions and advising foreign investors on potential investment opportunities in Nigeria. Beyond his legal practice, the Leonard Silk has held prestigious positions, including serving as the former president of the Lagos Court of Arbitration. I thought to be clapping by now. Africa's foremost dispute resolution institution. He's also the chairman of the board. Has also served as the chairman of the board of directors of the Nigerian Mortgage Refinance Company. Among his notable contributions, he has served as chairman of the Nigerian Bar Association section on business law, a member of the General Council of the Nigerian Bar since 2011, and chair of the NBA's working group on the liberalization of legal services in Nigeria since 2012. If I keep reading his profile, we will not finish today. So please welcome Mr. Candide-Johnson.
Thank you very much. Thank you for inviting me, even though I'm told that some people thought I wouldn't show up. So I wanted to collect the plaque, but they sent it to the right. Anyway, I think we have an hour, or do we have just 50 minutes?
An hour.
Okay, all right. Well, thank you very much. As I said, it's a pleasure to be here. I'm really impressed, actually. So many lawyers will come out on a Saturday to learn about things that they have done otherwise. How distinguished practice. Last time I saw her was on the dance floor, actually. That's her become so. It's good to see her working. Now, legal ethics, in my opinion, is the heart and soul of law practice. Why? The role of the lawyer in society is not just about how they make profit. I think that, someone's going to have to help me with the slides, because I think I'm going to the, well, okay, you can leave it there. Oh, this is excellent. Oh, fantastic. So it's oh. Let me see. Yeah, sorry, I'm not very technological. I will argue that. Because your gadgets say otherwise. So, okay, to the right. Okay, so that's the way. Okay, great. Okay, in Nigeria, we've had ethical rules and we've had a rule of professional conduct from the time our profession started. I think the 61, 64. But some people don't think that we operate at a very high level of ethical practice. And there are many reasons for that, a lot of bad behavior. But some people don't know what to do. This is part of the problem generally with ethics. You have to have an idea about what is expected of you. You have to know what your task is, what the rules are. And then you have to know, in many other countries, an ethics board will give from time to time specific declaration statements as to what is the ethical way to behave in specific evolving fact situations. This doesn't really happen in Nigeria, so lawyers have to guess very often. So on occasion like this, and we will close as I've been instructed, by looking at some hypothetical situations and raising some of the issues that you may or may not confront. But then if you get into thinking about how to conduct yourself and your responsibility, you see the role of the legal profession, as I said, is vital in society. The duty of preserving justice, safeguarding rights, and upholding the rule of law is central to the role of a lawyer. And legal ethics is the guideline. It's the moral code. It's the guiding light. So I'm going to have to keep remembering to put this to my mouth, right? Okay. So, I wish. Okay. All right. Okay. Thank you very much. Okay. So, okay. Right. So, legal ethics demand that lawyers act with integrity, easily said, honesty, and loyalty to their clients. They must also maintain confidentiality, avoid conflicts of interest. I'm sure you were told this in the law school. Is there a course, right? You know, it wasn't until 1974 they started teaching ethics in American law schools after Watergate, when the conduct of so many lawyers fell so far below the public expectation. Because it's a revered profession because it's fundamental to the organization of society. So people expect certain things of lawyers. And if lawyers fail, the entire system of justice is damaged and is imperiled. So in addition to these responsibilities and these principles, which are required to contribute to a just and trustworthy legal system, lawyers also have to fight zealously for their clients. So these are contending responsibilities. You have to behave in an appropriate way because you need to represent the dignity and the effectiveness and to create confidence. Every lawyer has a duty to inspire confidence in the system of justice. This is a task beyond your earnings. But then you also want to win for your clients, and then you want to make some money. Some people think it's all about money. You know, about 10 years ago, I was asked to give a speech on ethics and its relevance in Nigerian legal practice for the Babatunde Ajibade, the Ajibade annual lecture. And the impression I started with was indeed that people are going to say this is a waste of time. I mean, where's the money at is what people want to ask. But I think as I continue with this presentation, you will hear my own impression that the behavior of lawyers, as it is fundamental to the efficiency, effectiveness, and the authority and the economy of law, is a better advantage to us than getting an extra 5,000 naira on some stupid case. So when we talk about legal ethics, there are three things really that are to be distilled. One is professionalism. It requires lawyers to act with diligence, civility, and respect for the legal system. I think that's right, okay. They must exhibit a commitment to serving their clients' best interests while adhering to the rules and norms of the profession. Professionalism also involves treating all parties involved in legal matters with fairness and courtesy, fostering an atmosphere of trust and cooperation. I'll come back to this. The second is integrity. Integrity requires lawyers to be honest, truthful, and transparent in their dealings with their clients, colleagues, and the court. They must avoid any form of deceit, fraud, or misrepresentation, as these actions can undermine the credibility of the legal system. I keep repeating, it's about the credibility of the legal system, which you will have a duty to protect. And the third aspect of the ethical behavior of lawyers in regard to any piece of work is competence. It is a lawyer's duty to provide competent representation to their clients. This includes possessing the necessary knowledge. And this is something that has been highlighted in the latest rules of professional conduct. But in other countries, in many states in America, to take on a case that is beyond your skills is professional misconduct. Some that should remember, they tell you there's a case in space law, 20 million naira. Well, if you can't do it and something goes wrong, you have breached your responsibility to your lawyer, to your client, and to the legal profession. So lawyers, therefore, have to continually update their knowledge and skills to adapt to evolving legal landscapes and ensure the best possible outcomes for their clients. Now, negotiating contracts is only one aspect. I don't know what else you've been taught in this course, but negotiating contracts is something I think which every lawyer will do at some stage. And there again, in the fog of war, the challenge for you is what are we going to do? Am I going to gain all advantage from my clients? Is that the task? Is the task to escape with them paying the least they can pay for the smallest amount of work? Or is it in building a contract which is durable? I think that the ultimate responsibility of a lawyer on both sides is to create contractual relations that are durable. They cannot be durable if they're prone to attack for deceit, for fraud, if they're prone to attack for misrepresentation, and if there's no real consent between the parties. I say this to people in many instances. Whenever I'm negotiating a contract, I ask them to say what they want. Clarity is extremely important. If you know what your client wants, you need to know what the other side wants, because you have to negotiate this. You know, some years ago, I remember negotiating a farm out agreement with some, on behalf of my client was a foreign corporation, but the Nigerians involved. And after a series of meetings, what struck me as the verification of the work I was doing was that the big chief, who was on the other side, we came for a meeting, I was there, my client was there, and his lawyer was not there. And he said, I'm willing to go on with this meeting if Mr. Candide-Johnson is present. He was willing to go on without his lawyers because he knew that I had exhibited the responsibility of ensuring that every aspect of everybody's contractual rights was understood and was effective. And this, from time, he's a big pot, so I don't see him, but I always remember that, and I'm glad I remember to tell you that today. So, negotiating, drafting, and reviewing of contracts are processes which are fraught with ethical issues. Negotiations require zealous advocacy, taking maximal positions. Other times, they require delicacy and balance. Reviewing and drafting complex contracts is a similar ethical minefield. If you discover that the draft of a contract contains materially incorrect assumptions about the law, but which will benefit your clients, do you have the duty to disclose or correct the error? Just keep that in your mind. In the same way, if the contract contains faulty assumptions about material facts, must you disclose the faulty assumptions? And how do these rules apply when drafting a contract? When you know a counterparty has made a faulty assumption benefiting your client, must you say? When a counterparty makes a faulty factual assumption, must you correct? And are you ever ethically obligated to rescind or restate a contract? So the tension of ethics in negotiations is between zealous representation and deception and your duty to the profession. And it may be easy, I use the expression the fog of war, because you know, you're in it, and really, it's a big case. The transaction, your client wants something, and really, in this environment in particular, where professional regulation is not as acute as it should be, lawyers, I think, are more amenable to undue influence by their own clients. This is a danger to your professional reputation, and it is ultimately a danger to your ability to conduct legal practice for the long term. If a lawyer can't be trusted, I don't care how much money he has, I won't work with him, certainly. And a lot of people take that view. And as economic capacity increases, more people are able to do that. And they will say, I don't know this guy. I'm not going to be. I was in a case and someone told me they were going to add a lawyer who I consider to be dubious, but a big pot. I like that expression. And I said very simply, if you can instruct whoever you want to join this case, but if you instruct this gentleman, I will withdraw. And he instructed this gentleman and said to me, your fees are going to be paid. This gentleman is going to work with you. And the next morning, discontinued the case. Of course, I still got paid anyway, because two things are certain. The most certain thing is that I will get paid. Now, when you want to decide how you approach the task of a contract in this negotiation, I like to break things down into pockets. So we know that we have to know what are you trying to achieve when you approach the negotiation of a contract? This is the question, because understanding how a thing is made up helps you to understand the purpose and helps you understand what you must do to achieve it. Now, there are general theories of the law of contract. There are at least 5 prominent accounts of the fundamental principles of the common law of contracts. Okay? I think that's the next page. Oh, well, no. Okay, let me just go on. I think maybe you mix them up. But first and foremost is that contract law enforces the basic moral duty to keep a promise. Now that you can see how that resonates with ethics. Secondly, a related though distinct view presents contract law as enforcing a duty not to harm others. These are legal philosophies at the foundation, and this is about talking about the theory of contracts. A third conceives of the law as not enforcing parties' non-legal duties, but as promoting efficient investment and exchange. It's about business. An association with economic theory gives this approach a prominence in legal scholarship that outstrips the philosophical attention it has received. So this is also an important function, creating a workable contract and advancing the economic progress of your environment. A fourth position emphasizes that contracts establish a distinctive relationship between the parties to them and grounds contractual obligations in the value of collaboration, acting jointly with others. I remember watching a program about a Harvard professor teaching contract exactly in that way. He gave people a 200 or 300 cases to research, all these law students. And the law students, no team could get all those cases. And all of a sudden, it struck one of them that if we ask those guys which cases they've done, they summarize for us, we summarize our case and give it to them. And then they came back and everybody had done it. And he sat down and he knew the lesson had been learned, but he wanted to emphasize it. And he said, I think the guy was Hart. And he said, Mr. Hart, what have you learned from this exercise? He said, the necessity for contract. So it's important, and it's an important philosophical underpinning. People, you can't do things by yourself. And you can't take all the benefits of any transaction. So you have to recognize that in any contract, you have to give something if you want to take something. And this attitude, while being ethical, is also effective in ensuring that the system works, that contracts are durable. And this is the foundation. If every contract goes into dispute, there's no point. It's economically injurious across the board. So deciding what are the elements of a contract and how to approach them requires a lawyer to exercise his skills. Now, I think it's Article 16 of the Rules of Professional Conduct. Impose upon every Nigerian lawyer the duty to exhibit skill and to do only cases for which he has capacity and ability and experience. You have to know if something's beyond your experience, you have to ask somebody else to help you. That is ethical. And there's nothing wrong with sharing fees with people. You know, some people would just say, I'll tell you what I think you should do. But I see this on many social media platforms where lawyers are. I see people, some guy will send a message saying, does anybody have a precedent for something transaction? You know, even at this age, if somebody asks me about something that I know about and I do every year, I'm going to research it. If anybody refers me to a document, there's no day I'm not reading. I mean, I have a very boring life, obviously, but there's no day that I'm not reading. You have to start from the beginning on everything. So I do matrimonial causes, or I do arbitration. There's no day I'm not reading something about arbitration. So you have to challenge and test yourself. And if you don't know something, you have to ask somebody. So sometimes if you ask somebody who's your senior, look, I'm doing this transaction, you need to understand what it's about. It's not about grabbing a precedent. That is professional misconduct. It is negligence to be able to, and this is why you find all these difficulties. They're talking about this failures and pathology in arbitral clauses. That's because people don't understand what the clause does. You have to know what it's about. You have to know how a transaction is built to understand how it must be regulated. If you understand how it must be regulated, you're able to exchange with other party on a constructive basis, and you're able to understand how your ethical responsibility can be executed in that transaction. So, of course, for a contract to be binding, it must contain two elements. There must be an agreement about the offer. One party has accepted it, and there must be something of value that is exchanged for something else of value, consideration. Now, you cannot have a contract without those essential elements. That is, to know that means you are qualified as a lawyer, you have certain skill. That is the skill you bring to a contract. When I come to negotiate with you, I need to know, both as a matter of skill and as a matter of ethics, that your consent has been properly captured, that you understand what you have agreed to. Every day, I see cases, especially in arbitration, senior lawyers saying, filing papers saying, undue influence, duress, oppression, mistake, non est factum. I have not seen a case where they've been able to establish this deficiency, but then signing a contract is not the end in its durability and its effectiveness. You have to be sure that it is, unless people understand what they have agreed. There are people who are going to object to an event and who want to cause trouble. But unless people understand, it's difficult to hold them. And there's a whole series of legal impediments which will vitiate that contract. Rescission for fraud, for misrepresentation, for mistake, for undue influence, for duress. Those are things that you have an ethical duty to because it deprives the consent of legitimacy. It is your duty, to repeat again, to ensure that there is proper consent so that the contract is effective, because this is the reason why you are launched upon the world and as a lawyer. Now, okay, I think I've gone past this. Okay, let's go to confidentiality. Just one point. I mean, I have highlighted the paragraph in the rules of professional conduct. That's my scratchy writing. Privilege and confidence of a client. Except as provided under paragraph 3 of this rule, all oral and written communication made by a client to his lawyer in the normal course of professional employment are privileged, and a lawyer shall not knowingly reveal a confidence or secret of his client, use a confidence or secret of his client to the disadvantage of the client. I think everybody knows that. So confidentiality is very important. And you cannot use, by the way, the confidential information you've obtained in one transaction in another transaction. So it's worth remembering these things. The tendency to do so would be easy, but you need to caution yourself. And people may be getting away with ethical breaches in our country right now, but it's not going to be like that. You see, by the time I've left the profession, it may still be as bad as it is now, but you are all in your prime. You're going to face the consequences, because it is crisis that causes law to respond to the challenges of failure in professional regulation. And there is a crisis in our system of justice and in our lawyering in Nigeria at this moment, and it will be rectified. So you don't want to be caught at the time and find yourself not being able to practice anymore. Conflicts of interest, this is already dealt with that section. Can I see the next? Unlawful conduct. Okay, this is something else I wanted you to read, to draw attention. I think everybody has seen the rules of professional conduct. Yeah. Are you sure? Anybody who hasn't seen it should just admit right now, it's fine. We'll give you a copy. So let me, I think it's better for me to read from here than to read from my computer. Unlawful conduct. 15. In his representation of a client, a lawyer may refuse to aid or participate in conduct that he believes to be unlawful, even though there's some support for an argument that the conduct is legal. That's an important point. You may be able to explain and rationalize it as being legal, but you know what is lawful and not unlawful, and that is, again, a test of your skill, your judgment, and your professionalism. In his representation of his client, a lawyer shall keep strictly within the law, notwithstanding any contrary instruction by his client. And where the client insists on a breach of the law, the lawyer shall withdraw his service. Is that possible? The brief is 250 million.
It's possible.
Yeah?
It's possible.
Anybody else think it's possible? It's not possible. Okay. Okay, all right. Can I see the next one, which I want to highlight? Illegality and fraud. Counsel cannot assist his client in conduct that lawyer knows to be legal or fraudulent. That's obvious, is it?
Yes.
But what about backdating the documents? What about removing a page from page 3 of the contract and putting another one inside there? That's what they intended, and the other guy is a useless man. No, okay. Knowingly engage in other illegal conduct or conduct contrary to any of the rules. Where in the course of his representation of his client, a lawyer receives clearly established information that the client has perpetrated a fraud upon a person, court, or tribunal, he shall promptly call on his client to rectify it, and if his client refuses or is unable to do so, he shall reveal the fraud to the affected person or tribunal, except when the information is a privileged communication, but where the person who perpetrated the fraud is not his client, the lawyer shall promptly reveal the fraud to the tribunal or court. How many people have seen fraudulent conduct and have not reported it? Okay. All right, well, it's just worth thinking about. So that is I point those out because those are express responsibilities. You see, another point I should make is that the rules of professional conduct give specific guidelines to lawyers, but this is not the extent of your obligation. I think I started by saying professionalism, skill, integrity. You know, in the US, they didn't think they needed to teach ethics until 1974 because they assumed that the type of people who were lawyers understood how to behave. In Nigeria, I guess in the 60s, we had a more homogenous group of people practicing law, and it was to be expected. I remember going with some colleagues of mine to go and see Sade Tokunbo Ademola. Some people don't even know who that is, but that's fine. And does anybody know who Sade Tokunbo Ademola is? Yes, okay. So we went to see him, myself, some lawyers, Demola Kinrele, Tassim Alemashan, to talk to him about a journal we were starting. And you know, he stood there in his house next to law school, and he said, he asked everybody who they were. And then he said, yes, he said, the law is for the children of esquires. Now, not everyone's a child of an esquire, but everybody who practices law must behave like the child of an esquire. That is a gentleman. But now you cannot, it's not possible with 40,000 lawyers to know who knows how to behave, because I can tell you there's certain things that I was taught with my baby's milk. So I know what I should and I shouldn't do. It is intrinsic in my natural behavior. Many people are like that. But then there's some people who may not know, but that's fine. You can join the legal profession because you admire it. I remember Chief Ayuli saying his father used to walk past the High Court and used to remove his hat when he walked past the High Court in Lagos. And he said that he always wanted to be a lawyer. And Ayuli, not the son of a lawyer, was always properly turned out, professional, on time. And I never heard him accused of any unethical behavior. So this again it just shows you that you can become what you're supposed to be. Another nice story I'll tell you is a friend of mine whose father was a judge in Ijebu, in the old Ijebu province, says that, you know, their house was like 1.5 kilometers to the main road. But when people walk past the front of the house, they remove their shoes. This respect for lawyers and for the law is lost because, like my own father used to tell me, the best defense of a judge and of a lawyer is their dignity. You cannot have dignity if you're a crook. Your dignity, you will stand firm and you will say, this is my judgment. This is what I will do and what I won't do. And it's an important, you will differentiate yourself from other people when they look at you and they say, look, if someone gives you 100,000 naira, you will spend it. But if they don't give you 100,000 naira, you're still working. You have to be patient to wait to do. Doing the right thing, in my experience, always works. So I want us to consider some hypotheticals, some cases which I will put up. So can you just check if there's another slide I may have missed there? Okay, I spoke about that already before, about increasing the durability of contracts. You have to make it clear what people intended and what they've agreed and represent accurately. So clarifying whether yes means maybe or no, and signed and detailed contracts are considered to be morally, legally, or in reputation, or just amount of declaration that a working relationship now exists. You have to understand, did they intend to contract? Including clauses and discussion regarding how any future misunderstanding will be addressed, because there's always going to be misunderstandings. This is why construction contracts have DAB tribunals, because they know there's going to be, that's a dispute arbitration tribunal, because you create these tribunals to determine issues because you don't want to stop the construction. And I'm not talking about construction of a house. You're building a tunnel, or you're building nuclear infrastructure. You cannot afford to stop it to go to court and appoint an arbitrator. So they have standing tribunals. So that's important because you want to, again, to be sure that there's somebody who the parties trust to determine very quickly what they intended. Attempting to agree that a final determination of any future problems with performance will be in court or arbitration. That's your previous lecture. Not walking close to the line on any of the legal rules, such as duress, deceit, vague terminology, or illegality, and this will give other parties the opportunity to claim a loophole. Because again, we want to be sure that the contract works. This is the task, not to win, but to be sure that the contract works for the purpose of the business that your client and the other party are into. Sorry, can I see? I'm not really sure what's next, but whatever it is. Right, okay, hypotheticals. All right, so let me give you some hypotheticals, but I want you to consider them under the following guidelines. In determining whether conduct is ethical, it may be helpful to examine, one, whether there is a duty to read a draft, whether an affirmative misrepresentation has been made, because it'll come to you when I give you the scenarios, whether there is a duty to disclose, and fourthly, what the reasonable expectations of the parties are. Now, the four hypothetical situations, let me share them with you one by one. The first lawyer tenders a draft contract. The second lawyer returns it, saying that it is acceptable, and both parties sign it. The second lawyer has made changes in the draft and did not call the first lawyer's attention to the changes. This is actually the introductory paragraph of a case in 1985, an American case. The question is, did he act unethically by failing to inform the other side that he had made the changes? Anyone care to answer?
Yes.
Yes.
Okay, why? Can't he just say, well, he signed the contract, it's his job to read it?
No. There was an obligation to look at what was.
Yes. The first lawyer tendered a draft contract. The second lawyer says it's okay. And both parties sign it. However, the second lawyer had made changes to the draft and did not call the first lawyer's attention to those changes.
It's unethical because the draft does not belong to you. The first lawyer prepared the draft.
Okay.
So he owes an obligation to inform the first lawyer, that certain changes had been made because that document is not his. That's to begin with. And then, of course, that ultimately alters the balance of the addendum that signature is supposed to have.
Okay. Well, that's an important point. Any other? Okay, this lady has a thought.
Okay. The fact that the second lawyer spoke to the first lawyer saying that he was okay with that contract automatically communicates that you didn't make any alteration to the draft I have sent. So you're not making an alteration without informing the other lawyer was actually unethical.
How would you invalidate that document? Is it a misrepresentation? Is it fraud?
It's fraud.
Is it
That doesn't mean fraudulent.
Okay. So the representation, well, I'll tell you, I mean, if anybody has a contrary opinion, we can. Okay, this lady has a contrary opinion. Then, so the gentleman has the mic.
Yes.
Go ahead.
Okay, I think it's also expected from the lawyer that is signing to go through the document for the second time before appending his signature.
So you say it's his luck he didn't read it. He cannot rely on any representation by the party who tendered it back to him.
Yes, the other party made a mistake of professional misconduct on his side, but it's required. The other lawyer that.
But isn't that contract going to go to court? Isn't that inevitably going to be a case that goes to court while the business stops? That's the economic aspect of ethics. But even as a matter, our own rules say you must give consideration and respect to your colleagues. So you want to say something?
Thank you very much, sir. So yes, while the second lawyer might have misrepresented facts,
yes,
the first lawyer also has an obligation to be, professionally prudent.
Okay.
So it was professional negligence on his part, not to have read the document after it went to the second lawyer. So both of them have their issues.
Okay. Gentleman with the dark glasses.
So essentially, a lawyer has a duty to be candid with other lawyers, not and and to also be candid with the court.
So candid with me too.
Exactly. So exactly. So
okay.
So when the document was returned,
Yes.
and he actually said it's okay, he has actually made a fraudulent misrepresentation because he's made changes to the document. So knowing that by saying it's okay, the other party will simply proceed to sign it. So the intention was clear. He wanted to gain an undue advantage.
Okay, well, that's what the court held in this case. The case went to the Sixth Circuit Court in the United States Federal Court in a case called Hand and Dason Hudson, 1985. And the court held that the signature had been induced by fraud and that the agreement should be reformed to conform with the understanding of the parties. The decision was that by returning the document while saying it was acceptable, the other lawyer had effectively said that the document as prepared by the first lawyer was acceptable without any change. But you'd be surprised how often this happens. I say trust and verify. People think that, and another thing I always say, when people say one lawyer is brilliant or not brilliant, I'm not a brilliant lawyer. I'm a lawyer who reads everything. So someone asked me, gave me a sack, I said, are you going to read those? Well, my juniors will read them, but I will read them myself. Because there are things that I will see in 5 minutes, they will not see in 5 hours or 5 days. But that's fine. But it's very important. There's no substitute for doing the work in law. No matter how fine you are, no matter how you talk, and it doesn't matter. You see some lawyers in court and they turn around, they're addressing the audience because they're feeling really cool. That's not the job. As a general rule, when one lawyer makes changes to the other side's draft, the ethical practice is to inform the other lawyer of those changes. But what if the changes are made before the draft is presented to the other buyer? That is, they're made to a form contract. The party preparing a draft alters a standard form. Assume that the lawyers are negotiating a contract for the sale of real property, and it is customary for the seller to pay certain closing costs. The seller's lawyer tenders to the buyer's lawyer a draft contract in which the seller's lawyer has altered the customary language to provide that these costs are borne by the buyer rather than by the seller. The buyer's lawyer reads the variable terms, but not the boilerplate terms, and does not notice this change before the client signs the agreement. At the closing, the change becomes apparent. You're laughing. You think he's very smart. He has shown that guy. So, did the seller's lawyer act unethically in altering the customary terms without informing the buyer's lawyer? Anybody? No? Okay, well, I'll answer my own question then. All right, well, it is clearly sharp practice. And that, again, is a breach of your duty of integrity, your professionalism. As far as I'm concerned, a lawyer should not be accused of sharp practice, even if you can't be punished. You remember the rules talking about, even though it may be legal, or there is a plausible argument about its legality, you cannot, as a person of integrity and a person who stands on the professional responsibility of a lawyer, take refuge under sleight of hand. So, that case, it was held that he didn't have a duty to disclose the fact that changes were made to the customary terms. No affirmative representation was made, and the buyer's lawyer may not be justified in assuming the draft contract contains the customary terms. It was a failure of the other lawyer, and indeed, he gave him a document which he should have read. That, again, is negligence on the part of one side of the lawyer. Now, what if the changes are disclosed, but not the consequences of those changes? The lawyer requesting a change fails to disclose the ripple effects. The first lawyer asks for a change in a term, which the second lawyer agrees to. But the first lawyer does not inform the second lawyer that the change in that term affects a term in another part of the agreement that is not favorable to the party represented by the second lawyer. Okay? An example might be the choice of a law provision, where the law in the chosen jurisdiction affects another part of the agreement. Does the first lawyer have a duty to inform the second lawyer that the change in language may affect the other part of the agreement? Anybody thinks he should?
The presumption is that he knows the law.
Okay.
And the consequences thereof.
Okay. Anybody thinks he has a duty to help his friend?
That would, it would have been a different case if we were talking about lay people.
Okay.
And the issue of consequences. But if we're talking about professionals, you have an obligation to be competent in the law that is being.
Even the RPC does say that as well. This is again about exercising skill. There's a famous scene in a famous film called Body Heat. I don't know that it's an old film. Nobody has watched it. It's about the law of perpetuities. Anyone know what the law of perpetuities says? Was trust not compulsory at universities? Is it not compulsory in universities here?
Yes. Equity or trust.
Okay, so who knows what the law of perpetuities is? So you know that what it is?
Trust lasting forever, usually maybe 25 years in some jurisdiction, etc.
Correct. The policy of the dead hand. The law frowns upon controlling property for an indeterminate time. The law of perpetuity says that a gift must vest, if it vests at all, within 21 years of the falling of a life in being at the time the gift was made. So if there's nobody who is mentioned in the gift who is alive, then it must vest within 21 years. So in that famous case, the lawyer had gone and left and basically gave a gift which did not vest for 21 years, voiding the entire will. Now that's a very big problem. And the other lawyer, did he have a duty to tell him? I guess not. The way this was resolved here is that one lawyer does not have to educate another as to the legal effect of a contract provision. As long as no affirmative representation is made, in fact, the lawyer's duty of competent representation, Rule 16, would require the recipients to recognize the ripple effects. Now, with modern technology, which as you know, I'm not familiar with, these problems are exacerbated because nowadays contracts are not drafted necessarily with exchange of drafts over time, but they draft them in real time using Google Docs. The first lawyer can suggest a change by typing it in, and the other lawyer can assent or not. The alteration itself is clearly disclosed, but not the effect that the change in paragraph X will have on paragraph XX. This is a significant drawback to real-time drafting, for such repercussions can best be discovered by reviewing the document in its entirety on paper. Alas, the pace of modern business may not grant us this luxury. A lawyer must therefore know the transaction well, including knowledge of how all parts fit together. You are entitled, in certain circumstances, you can't, it's like bullying to take advantage of the ignorance of law on the other side. But it is his responsibility. I couldn't say in a transaction that a lawyer who's 2 years at the bar came and he's on his own. It's not, it'd be humiliating for me to, so I'd rather say you need to consider this carefully because I would feel that I had a better obligation to say it. I need you to know and your client needs to know what this is going to do because it reflects on my integrity and my own personal reputation. But strictly speaking, it may be his responsibility, but you have to consider again that a lawyer is making an example. He's showing how people should behave. He's trying to inspire confidence in the system of justice, which is fundamental to the good of our society. Does what you do, whether it's written in the rules or not, does it promote that end? This is an important thing. Okay, finally, what if an agreed term is omitted altogether? The final contract omits a term that the parties agreed to. The parties agree to terms of an agreement. One lawyer reduces the agreement to writing and both parties review and sign it. Later, the first lawyer realized that an important term has been omitted. This is what they call a scrivener's error in American practice. This second lawyer acknowledges this scrivener's error, but refused to modify the writing, which purports to contain the final and complete agreement of the parties. You've signed, it's all over. Should the second lawyer agree to reform the contract to include the missing provision?
The second lawyer did.
They agreed something and it's not in the contract. But then the other guy read it But that agreed term wasn't there. So it calls and says, look, we agreed that this money was going to be reviewed after 6 months, but it's not in the contract. What is your impression of that? Is it ethically sound to rely on that? We're talking about whether should he agree as an ethical matter. If you know that your colleague and you agree to a clause, and that clause has been left out by mistake, should you agree to change that clause? Or do you have to wait to go to court? Yes.
Yes, I think you have a duty to inform the other party because you agreed.
Okay, anybody thinks that she's wrong? Now, I know this is the session before lunch, right? Okay, so we're moving quite promptly to time. Okay, so there are multiple scenarios. There are multiple ethical issues. Every day, you're going to confront a situation which is dubious. You're going to have to decide for yourself whether the guidance I received from the rules, my understanding of how people behave in similar situations, and this is why being in a good firm like this one here is very important, because they will tell you can't do that. Because if you do this and the next thing it's in the papers that this is what you've done, it's going to, the damage to reputation is very difficult to undo. And make no mistake about it, however rich a lawyer is, it's his reputation that counts. At a certain age, you realize that there's really not much you can do with money anyway. I guess if you're 25, you think that you can do everything with money, but you can't. After a while, you know, there's not, you don't need that much. So the lure, the delusion that you need to acquire money at all costs is dangerous and destructive. And more importantly, it's destructive to your reputation and therefore to the effectiveness of the system of justice, which, as I said, from the start, contracts, the purpose and the theory of contract is the organization of relations, promotion of business, and the creation of trust in people collaborating across the board. If you can't trust a contract that you've signed, if you can't trust that a lawyer was involved, I don't know whether everybody understands how important I think that. I will always ask, sorry, who was your lawyer? I ask that sometimes, even in court proceedings, sometimes a document will come and first, yes, it must be his junior, you know, but even then, you know, if my junior drafts something and leaves my office, it may happen, I may make a mistake, but I'm responsible. And that junior will know that I'm responsible thereafter. So it's very important, but then this is the point. So in all these situations, as I said, the rules don't provide a comprehensive guide. They give you an indication of what your responsibility is as a lawyer. The first article tells you what the lawyer's responsibility and duty is. The rest of them simply develop aspects which have been foreseen, but there will be aspects that haven't been foreseen, and you must determine for yourself in any ethically challenging situation, how do I respond in a way that promotes my professionalism, my skill, and the proper organization of legal affairs in our environment. Any questions?
Thank you very much, sir. I, having followed you for a while, no, I wasn't expecting anything short of the presentation we just got. I would like to ask, and maybe this might not be the appropriate forum, but you could just dive into it if you can. Shouldn't we have a situation where instead of our code of professional conduct being the static nature that it is, we from time to time have like the words you use, guidance on different aspects, because the ethical requirements change every day. You raise the Google Docs thing. Up until this minute, I had never really thought of it as a thing, but it's really there. There's room for it in the industry that we now find ourselves. And you don't want to be the lawyer that is left behind in the scheme of things. I mean, what can we do, or what approaches should we have to resolving those dilemmas, because they will occur?
You're right. I'm a cheeky fellow, so I asked a friend of mine who's on the body of benchers. I said, you know, there's no routine and regular periodic guidance to lawyers as how they should respond to situations. But you're on the body of benchers, I said. Apart from the fancy dress, what exactly do you guys do? I think he's blocked me. So in other countries, this is what the body of benchers does. They will tell you body of benchers guideline, or the Bar Council in England guideline on tech transactions involving cryptocurrency, guidance on lawyers receiving money in advance of their clients' inspector property transactions, because they have to respond. But then I think that the leaders of our profession, to an unduly large extent, think that ethics is not important. It's a mistake. And they're giving bad examples to the lawyers that come after them. But you're right. You need to have an ethics committee of the body of benchers. The Bar Association needs to have an ethics committee which makes recommendations as to emerging trends in transactions and in business dealings, and recommending how, when those conflicts or when those ethical issues arise, they should be dealt with.
I might just want to follow up by saying,
sure,
we have a very interesting clause in, although not related to this, and that's the issue around advertising. That is neither here nor there.
Yes.
If you run a poll,
yes,
of many lawyers under 20 years and, well, 20 years and below, their understanding of what advertising is and what those of our leaders are, they are distant.
Yes.
And many things are responsible for that.
School, they said, Ebenezer Obey should not wax a record in your name. That was the example that Igbiranke gave. And that is the state of the art. That's state of the art. Now, the rule about advertising is antiquated. The fact is that lawyers should be able to represent their achievements, but then other countries regulate it. You can't diminish the work of another person. You can't make a false claim of what you've done. You can tell people what you've done successfully. You can tell, you don't be garish and excessive, but the fact is that you've picked on a simple issue which can be easily addressed, which can be easily reformed, and which can be dealt with from day to day. So what happens if you're on your Insta? See, I just wanted, I know Insta, I know. Okay. Anyway, all right. So I'm talking here now. This is going to appear on Instagram. Have I reached the advertising? I didn't say anything about myself. I didn't say I'm the best lawyer in the country. I simply said I was speaking today at an event with young lawyers, and I spoke about ethics of contracts. So I know that without any regulation, that the things I can't do. I can't go to the press and say, all the lawyers here, I'm the one who owns them. They are the ones that just, oh, my boys came for a meeting. This is the problem. So, but people will know, but some people, honestly, not just in law, there's some people who are pathological in their embrace of falsehood, and they don't know the difference. And when you catch them, they'll say, or can't somebody play with you? But then this is quite popular, but I don't accept it. You know, if you've done that, you have to accept responsibility and step back. You know, if I do something wrong, I expect to take the consequences. What's the penalty? Because that allows me to go forward without any baggage. What is the penalty for what I've done? Can I take it and then move on? So that is the way, but you're right. We need to do so. Gentleman over there.
Okay.
Yeah, but you're like a repeating record. So after this guy.
Okay. Thank you, Leonard. So I think this is the highest point of today's event, because we almost agree that if you want to be a lawyer, law practice is anchored on ethics and professionalism, no matter how we pretend about it.
Yes.
So you've made some valid points. I mean, I listened to you when you said that if a lawyer accepts to act on a brief that is beyond his or her skills, that amounts to professional misconduct.
Correct.
That should be on the marble.
Yes.
And we know that it happens.
Yes.
Oh, give me XYZ template.
Yes.
You put it together, you go to court, you manage to succeed, but you don't know it.
Yes.
Now, beyond that, talking about professional
If
misconduct.
you do that in the UK, or you do that in the US court, you'll be before the Professional Standards Board the next morning.
Well, here,
Your license will be yanked.
I've had someone who doesn't talk to me today because I refused to give him a template on arrest of sheep.
Yes.
And the reason is not because I am holding it. I have tried it in the past.
Yes.
And that arrest ended up being discharged 2 days after.
Yes.
And I was now hired to
Yes.
make amends.
Yes.
So what I told him that, why don't you collaborate?
Exactly.
That's the point. We can split fees.
Yes.
It's against you wanting to do it on your own and thinking that you will become an expert overnight.
Yes.
But that's by the way,
Yes.
because we all learn. If you bring certain briefs to me, I won't touch it. I will call one or two friends and say, I have this brief.
Yes.
What is in it for me?
Yes.
There's no hidden secret about that.
Yes.
Now, coming to the meat of the matter, young lawyers, middle-aged lawyers, we're all concerned about ethics. But what we see over time is that there are people who have flagrantly and abysmally flouted the rules of professional conduct. And young people still see them walk free. Nothing is done. So you made a statement that no matter how rich a lawyer is, if you don't have integrity, yes, it's beginning to sound like a cliche because young lawyers see people who have money almost get away with everything.
Yes.
So since we don't have any other profession to call our own,
we have to defend it.
How can we practically, well, thank God for people like you. Some of us are looking up to you and we're trying to maintain the standard of ethics. What can we really do to salvage whatever is left of this profession?
It's a very difficult problem. It's a very big problem. You know, I was chairman of the disciplinary committee A, they called it, of Lagos some years ago. And they would dump these files on you. 60 cases. But we work out a system. Lawyers on that panel, myself, Professor Jogu, one of Professor Kasmu's daughters, Kemi Pinero SAN. We were making decisions on these cases on a turnover of no more than 14 days. Because we simply say, everybody gets a copy of the papers, share them around everybody reads it, one person decides to write it first draft is circulated, comments, and it was out. And this was a big issue. Then one day, a lawyer came to my office and said to me that she has a case before the tribunal. I said, I'm not aware about it. What is the situation? She says, it is on its way. So I said to her, I can guarantee you two things. One is that we will decide this swiftly. And secondly, that we will say exactly what we find. As it happened, this was a very well-connected lawyer. So anyway, the plot to sabotage the disciplinary proceedings in that case originated directly from the Executive Council of the Nigerian Bar Association for very sordid reasons. If I'm put on oath, I will name names. But then it became an issue. Subsequently, this person applied for the rank of SAN. And I wouldn't say how that ended, but I personally sent our report to the Chief Justice of Nigeria because I believe that the integrity of our profession is the foundation of its future. But the disciplinary system doesn't work. They will come and they will say, so I remember some SAN telling me he filed a disciplinary case against some of his relatives, and he met me in court, and this guy's senior to me, he's passed away now. And he said to me, that case, and I said to him, I will make the report to the Bar Association when we finish considering it. Sir. That's the end of the matter. Or the big lawyer came to ask me in an arbitration. He wants to discuss so-so-so's case. I said, Prof, I haven't read the matter. I'm not going to discuss it. I think you ought to leave the matter alone. This was at a bar dinner. So people have to take the consequences. Someone said to me, some lawyers are intimidated. Lawyers aren't intimidated by threats to their life. They're intimidated by the prospect of money. So you blink your eyes. But I know outside the country, and I do arbitrations outside the country, and you see the disrepute and decay in our profession has gone so deep that the credibility of Nigerian lawyers across the world is very problematic. You know, I was telling somebody, you sit down there, you say they're the Chief Justice, and you go and testify as an expert in the proceedings in Paris, and then one small girl like this will stand up in his church and say, Mr. Babangida, did you do, well, can you look at page 4? And he would say, ha, because ha is the only response. Actually, I'll tell you a funny story. I was involved in a transaction recently, and they thought that they were going to bring, there's a big chief, and again, I won't mention the big chief's name, who is a senior advocate of Nigeria, maybe 10 or more years before I became a senior advocate of Nigeria, which is some time, since this is my 21st year as senior advocate of Nigeria. So that is some time. So I'm entitled to the keys of the house now, 21 years. We had this meeting and they bring this woman on and she starts talking about this matter, what? So I asked her 2 questions about the matter. She didn't know the answer. And I said to her, this meeting is a waste of my time. I consider the meeting closed. And all she kept saying was, ha. Until I left the room, just saying ha. This ha is a very, I don't know that everybody in Nigeria says ha, whether just in the Southwest. They say ha in the Southeast. But then you have to not care. You have to believe, you know, for me, law is a religion. It is something which I have faith. I believe it is the foundation of every progress in human society. The only way you can organize people to work together, to build things together, is collaboration and unification. And you only do that if there are rules which everybody respects. The law cannot be breached by some people. And it doesn't look good if a member of the House of Reps gets 500,000 naira bail and some teenagers get 10 million. The law, there can be no rule of law unless the law is equal and impartial. It's as simple as that. So we're pretending, and this is what you have to fight for. And to be frank, it's not my fight anymore. It's your fight. Next session, we look at this woman with lights because she has too many questions.
Thank you very much, sir. So in one part of the RPC, we read that all communications with your clients is confidential. Then this particular slide, it's too far from me, so I can't read what's stated there. But are we required, when we are faced with illegality or fraud, are we required to disclose? One, what if we're called before a panel? Maybe it's a money laundering situation. What do we do as well? Is it just enough to say, oh, I'm not going to be part of this transaction, you just wash your hands off? Or you actually have a duty to disclose?
Under money laundering regulation, which is not a rules of question, I think that you have a regulation for this question. But it was manifest. If people tell you that they're going to do something, say, that's unlawful, that's your first duty. That's unlawful. If they don't resile from that course, you say, I won't do it. Sorry. So to start again, I'm sorry. I believe that the money laundering regulations impose responsibilities on everybody dealing with money to report suspicious transactions. But that's not a matter of ethics, that's a matter of law. As far as the ethics of the profession is concerned, I think that your first duty is to tell them it is contrary to the law and that these are the consequences that will follow under the law. If they insist on proceeding with it, you have to tell them, I will not participate. Now, if you don't participate, you don't know whether they did it with somebody else. You're not then it's not your job to monitor the transaction. But if it comes to your attention that this transaction has been done in this way, you will not be able to resist a subpoena because you cannot claim privilege for the acting an illegal ongoing transaction. You can't, if your client did something, if your client confesses to murder to you, well, you're still entitled to give him the defenses required in court. But if he's involved in a transaction, even in a criminal case, if the conspiracy or the legality is ongoing, you have a duty to report it. So someone says he's going to murder somebody in this room at 5 o'clock, and you see him getting a bus ticket to go to Lagos. I think you have an obligation to report that there is a danger, that this is what you know, and that does not contravene your response, because you have a responsibility to the law. These ethical rules are to preserve client confidentiality so the client can come to you for help, and to be sure that all the operations that lawyers undertake are respected and regarded. Who is it? Who is a lawyer is so important. That's why a lawyer signs a document. People have to be careful about it. Some things that happen these days, you really just wonder. And indeed, I've seen senior lawyers say they signed a contract that they didn't read. I said, you can't be 30 years post-call and admit that in public. Better to say that you were on drugs, frankly speaking. And I didn't read it. What is your reputation if these mistakes go past you? So it's a task. I hope that I'm happy to answer any other questions, but I just hope that if I leave you with nothing else, it's that your responsibility, professional responsibility, and that includes your comportment, as I said, arriving on time, your dealings with other people, how you speak. Your dressing is part of your ethical presentation.
Well done, sir. Please, I was going to ask you. A lot of people would come to your chamber and ask you that, where is your field of practice? And I'll be like, I do everything. So some of them would say, oh no, but there's a firm that I've been to, oh, this is what they do, this is what they do. But during court to bar, we're all called to be a barrister and solicitor of it. So I'm wondering, is it unethical that we're doing all aspects of practice?
If you're a genius and you can be an expert in every aspect of the law. So if you're a genius, you can be expert in everything. If you have an IQ of 340, for example, you can be an expert in everything. That's possible. But really, most people can only know so much. The question to ask is, what is your problem? My problem is that we have a contract for the hire of a spaceship. That's beyond my expertise. But nobody's going to come to my office and ask me, what are your areas of specialty? You tell me what your problem is, and I'll tell you whether I can do it or not. But I've had people asking me. Recently, someone had recommended a client because some lawyer, it's an international company, some lawyer who we worked for previously had moved to a new company, and then they recommended me to her boss, and he said, I could barely contain my irritation when he said to me, so can you tell me something about yourself? So I thought, Jaja Minimojoko. I was not, anyway, I explained to him what I was and sat down, and he said to me that so they would consider whether they would instruct us. I said, that's fine. This next conversation will be with my juniors on the call. But if you want us to do the work, we'll tell you what it's going to cost, and we'll try and do it for you. But we'll tell you what we think about the case, whether you pay us or brief us or not. So you take that for free. This is our evaluation of the case. It's 4 or 5 pages. And then you can decide whether you want this or not. And then 2 days later, we're delighted to inform you that we have decided what.
Last question, sir. So, okay, I'm an in-house counsel with an organization. Now, for we lawyers, if we are dealing with bosses, maybe like the group managing directors, that has to do with legal issues, and we're giving our best of our advice. Sorry, I will have to use Yoruba language. They are saying,
that means shut your mouth. What do you know?
Yes. And say it, I'll give a real life scenario.
That's not a well-governed company.
It had to do with land.
Right.
Family land.
Yes.
We knew by the time we did our due diligence and everything, when we came in on board, we realized that we bought land, it had a lot of issues on it. Right. And we kept on advising, let us, thank you. And the manager just kept on telling us, keep your mouth shut. In a situation like that we are bound by ethics to advise. So would you advise maybe we do like a formal legal opinion and there on record?
100%.
Let's communicate ourselves.
100%. I would always do that. You see, first of all, in-house is more difficult, especially if it's a smaller company who doesn't have regulation. My wife was general counsel of Total Energies. There is no legal documents that the MD will sign unless she has signed off on it. That is proper governance. Of course, I mean, these companies are accountable to the New York Stock Exchange and they're accountable to the London Stock Exchange. So they know the consequences of breach of governance. But you employ somebody to do a job. He's a lawyer. You have to hear his opinion. Otherwise, why you keep him there? And this is the way to do it. Sir, can I give you a short note on my opinion? You have discharged your obligation. And when they go back and look at it, even if they have shouted at you and told you to shut up, you don't know anything, they will know, and this will enhance your value. They will learn from their mistakes. You know, as I said, it's a challenge when you're in a small company. The chairman is the MD, the wife is the executive director, the children are also on the board. It's very difficult. But it then requires some delicacy. But I will always memorialize my opinion. I'm going to tell you what I think. And if you look at any standard form for giving opinions to banks, etc., it is hedged with caveats. This is on the documents we have read. This is my present understanding. The law is stated today. Sir, my opinion is that this is what is going to cost you. There's a story about the most famous, most expensive legal opinion ever given during the era of securities fraud in America in the late 1890s. Famous law, I can't remember his name, gave an opinion. He was sent a series of documents to analyze a potential security transaction. And he charged $183,000. This was his opinion. Transaction possible, criminal conviction certain. Signed it. And he sent it with his bill. And it's not at this country where they can run from paying your bill. That payment. All right.
On behalf of the chairman of the branch.
Thank you very much. Snatch it from my hand. Yeah. Let me join you. Okay. Excellent. Thank you so much.
Should I add something to what he said? Oh, yeah, sure. I have the permission of the chairman to add something to what he has said. It's like, I see down to the road, just 3 minutes. Let me add something to what he has said. If you are dealing with your direct boss, like the last speaker just said, and you know what Mr. Jemide said earlier on, you have to understand the character of who you are dealing with, estimate all those things. Since it might be a one-man business. Since we consider that we are just yes, from the facts of the matter, it will appear, it seems, the law says, it will suggest, right? Let me understand.
Thank you very much. So we've actually touched down. We're touched down and we're just going to disembark. But before we do that, we'd like to thank the law firm of Bawa and Ighodalo. So if you're a staff of Bawa and Ighodalo here, please can you come forward? Bawa and Ighodalo. There's some of you here. Can you come forward? Okay. So we want to thank the law firm of Bawa and Ighodalo, especially for providing their facility. You all know what power is expenses in Nigeria today. So to have us on a non-working day, air-conditioned, power, and all the rest, we just want to thank you and to show our appreciation. Yeah. Okay, let me join you. Okay, yeah. Come on, let me follow. Very much. Thank you. So when we started, we actually started out to have 70. Where's Chizoba? Chizoba. Okay, Elizabeth. Sorry, okay, all right. So we started out to have, usually, trainings they shouldn't be too large because they're designed to be very interactive, For instance, he was very interactive and a few other people. So, but anyway, I think we have close to 100 people here. We're able to capture about 90 or 80 something people on the register. Some people came in without, there were some glitches with the registration, but not to worry. For those who are here, we have the certificates. We have a tradition where we call you out, you have a handshake, and then you have because again, like the learner says, memorabilia, something to show that you're here, evidence to show you. So my colleague will start, and then as you hear, and then you just come forward, a handshake, and then. So whilst we're doing that, we'll just have lunch.
Okay, so I'm not sure if it's Mr. Office or me, so I'll just forward it to you.
No.
Oh, that's why I can That's why Clement. Okay.
So just once read it out, turn it.
For my money, and come out. I'm calling them. I'll be giving you today. But my money, she's coming already.
What's your Clement?
Yes, sir. Tewa Jagbe. Ibitola Akobi. Akpare Sophia. Imonike Wilson. Imonike Wilson. Indidiamaka Sylvia Ogufui. Chiditelu Ikueme. Chiditelu Ikueme. Oyinkosola Quadri. Oyinkosola Quadri. I think that's good. Okay. Adiza Jibril. Charles Anedeva. Charles Anedeva. Grace Ama. Grace Ama. Azizat Ogubo. Azizat Ogubo. Esther Debo. Esther Debo. Ṣẹ́gun Adébáyọ̀. Ṣẹ́gun Adébáyọ̀. Olúbùkọ́lá Martins Daniel. Ọmọ́wùmí Moses. Ọmọ́wùmí Moses. Ọlákúnlé Karimu. Ọlákúnlé Karimu. Dámiṣèyí Olúṣèyí. Dámiṣèyí Olúṣèyí. Bello Ọláníwájú. Bello Ọláníwájú. Nimi Edime. Nimi Edime. Justice Uka Ofo. When is done? Justice Ukafo. Andrew Enakifo. Andrew Enakifo. Okay, sorry. Ayodele Abiodun. Faith Nyaro. Faith Nyaro. Somto Ike. Somto Ike. Ruben Adepoju. Yeah, I think that's Somto Ike. Ruben Adepoju. Please meet. It's on outside. Ayoluwa Adetuji. Ayoluwa Adetuji. Mujib Abdul Wasiu. It's coming. Ubi Udumo. Ubi Udumo. Merit Odum. Ubi. Merit Odum. Okay. Benedict Oyabo. Benedict Oyabo. Keep it. Tell Chidoba outside. Chidoba, you say outside. Can I just ask her? Adesua Omozusi. Adesua Omozusi. Deborah Obio. Deborah Obio. Agbolarin Olorede. Agbolarin Olorede. Chizuwike Uwe. Olayinka Adetono. Olayinka Adetono. Bámiṣé Òjó. Bámiṣé Òjó. Bámiṣé. Olayinka Bọ́sẹ̀dé Adéjọrọ̀. Ìdòwú Ifá. Olayinka Bọ́sẹ̀dé. Munachino Ukachukwu. Munachino Ukachukwu. Adaku Ewenike. Adaku Ewenike. Damilola Adewale. Damilola Adewale. Okay. Ifyok Asuko. Ifyok Asuko. I can't watch and this calm down. Vera Uzo Anekwe. Vera Uzo Anekwe. Eric Uwani. Eric Uwani. Michelle Uzo Anekwe. Michelle Uzo Anekwe. Vera. Names in. Chisom Ogbuakane. Chisom Ogbuakane. Glory Edoasim. Glory Edoasim. Bola Tife Oguntunde. Bola Tife Oguntunde. Joseph Folaride. Ibukun Arabi. Ibukun Arabi. Michael Ada. Michael Ada. Chibuzo Esonwune. Chibuzo Esonwune. Abdurrahman Akiemi. Nami Aramu. Nami Aramu. Thank you. Jibola Salvador. Come. I know. No, can't take for the person.
Except I'll have to give you. Okay, you are eating. Send me a message.
Mubaraka Olaniyo. Mubaraka Olaniyo. It's coming. Olufemi Makojola. Susan Sinebe. Susan Sinebe. Abdugafar Mudati. Abdugafar Mudati. Ilkara Bogoro Patrick.
Sorry, can you wait till the end? Because we want to give one or two permission out. So wait till the end.
Ilkara Bogoro Patrick. Comforter Ketebu. Comforter Ketebu. Augusta Ogiemudia. Omobolaji Bello. Omobolaji Bello. Teslim Abdurrauf. Teslim Abdurrauf. Okay, Teslim is in. Take. Chibugo Stephen. Chibugo Stephen. Peter Undubueze. Peter Undubueze. Folakemi Femi Jemilohun. Prosper Edefu. Karen Maron. Ebikeniye Best. Ebikeniye Best. Ineka Ofuegbunam. Ineka Ofuegbunam. Okay. Sunday also. No yet. Ugochukwu Ifedigbo. Ugochukwu Ifedigbo. Agnes Asuko. What is it? Was not the attendant. Chioma Enro Gulam. Chioma Enrobulam. Aisha Ayomide Oladepo. Okay. Philip Oker. Chinoye Ngbafulu. Chinoye Ngbafulu. Kudira Karen Yerima. Deborah Akam Akai. Deborah Akam Akai. Samuel Okechukwu. Samuel Okechukwu. Olusegun Makindipe. Olusegun Makindipe.
Anyway, I just want to say, you can see the number of certificates we have, that we don't have people to pick them. And also, this is one of the challenges. And then some people are here and they don't have certificates. Some people they don't have to go back. So I think when we talk about ethics, which is part of what we need to be mindful, because some people register but have not come. And what that means is that they deny other people the opportunity to participate. But anyway, we'll continue to evolve to see how we adjust to the situation. So the branch secretary that asked that for those who want to post pictures, that the branch will be tagged. I think it's NBA Lagos, especially on the LinkedIn. I don't know what the other handles are, but probably know them. So please, if you are posting, tag the association. Also tag the speakers as well. I believe nearly everybody is on LinkedIn. So thank you very much. We've come. We're now embarking for the plane, and we wish you a safe trip. Okay, so what we'll do? I mean, no more songs. We just you don't want it. When you speak like this, make a command. You know, we are making a command. What is up? I'm sorry, what is happening? If we have not issued a certificate, we need to try today. So just stay on the side of the wall so that we can have the day properly taken down. Somebody have one out.
Excuse me, please, can we sit down, please, so that we have one that will us? Please, can you sit down? Can you sit down? Can you sit down, please, in an orderly fashion? Can you sit down in an orderly fashion so we can take comments just before we go? Okay, so I think you have a comment.
Okay, my question is, can we have like a general picture for those who don't have their certificate yet to show as proof that they actually attended, because some offices might actually need to show that you came here. So, yes.
That's it for.
So if you don't get a certificate, excuse me, if you are talking, you won't hear me. If you don't get a certificate, stay on the right side so you can take your name and then figure out how to get certificate across to you. Any more comments or questions? Sorry, sir.
Oh, yeah, we'll do, yeah, we'll do it. Yeah, we'll do it. I don't know where.
Okay, thank you. So many of us have received emails about partnership, CLE's partnership with BRIPAN. I don't know if you can just briefly talk about it while we are here.
Okay, I mean, so if you have any proposals, sorry, please, let's respect. Let's respect what we're doing. Some people are talking so that we can all maximize this opportunity. Your question is, how do you partner with the branch?
No. We received an email about CLE's partnership with BRIPAN.
Yes. Yeah, oh yeah. So the specifics will be sent out again the same way you got that information. So what the announcement is, there's a general partnership. So when they have their courses, we've negotiated a discount with them. And then, the same way you got that information, they will communicate specific trainings that they have and the cost and the discount and the rest of it.
All right.
Yeah. So just to announce the general partnership. Yes, ma'am. Do you need the mic? Oh, okay.
An appreciation to the committee. Thank you for a job well done. It was the well structured and insightful session. And in addition, I would like to say, maybe subsequently, because I got here this morning, I wanted to see that it sent out the confirmation email. I can see the confirmation email that I was meant to go back, right? So subsequently, if applications that were not accepted, probably an email should be sent ahead of time, not when we've canceled some appointments to be here and are asked to go back. So that's it.
So, thank you. Let me just address that point. I have to apologize and I take responsibility. We made the best plans in relation to this. We already have an established system. We cut off the application when we've got it to a particular number. Somehow, I don't know what happened. They said we called it a glitch, that a glitch occurred and it kept on registering people, and the people administering the system did not identify that glitch. So to some people that were not successful, they had sent the messages out, but to others, the thing was accepting their application, but then we weren't in copy of it, so we didn't know who and who came in. So that's why you have this sort of, we've never had a situation like this in the past. If you're not attending, we'll let you know ahead of time that, sorry, the application is on the first come, first served basis. So once we cut off, but we'll take notice and then, try and improve on the internal working so that we won't have this sort of problem. And what we try to do for those who came here, is to admit as many people as we can. So for me, the sacrifice of coming is worth being in the room, so long as it can take us. And that's why you have, overflows, in the hall. So we apologize for any inconvenience and I take full responsibility for it. So, all right. Wait, just hold on, please. Any more comments or questions? Okay. Huh? Oh, you're writing your names. Okay. Huh? Yeah, because they were not